Vlcek was trying to say something. I cannot hear him.
Go ahead.
Pane Vlčku, povídejte.
Paní překladatelko, já vám přeju překrásný den. A já jsem se chtěl zeptat, jestli ještě budeme mluvit předtím s právníkem.
Já se zeptám. Mr. Vlcek is asking if it's possible to have a consultation prior to this court hearing with his counsel.
I'm reluctant to do that because we've lost nearly an hour getting these proceedings underway, but I will confer with the judges to find out if they're prepared to grant that extension of time. So can you just wait for a moment?
Jenom si chviličku počkejte, jestli s ním chcete opravdu s právním zástupcem mluvit, tak já si to zjistím, protože už jsme přišli o hodinu. Počkáte si?
Ano, děkuju.
Thank you, I appreciate that.
Thank you.
Good morning, Mr. Vlcek.
Dobrý den, pane Vlčku.
Dobrý den, pane madam.
Hello, Miss Cassidy.
Could you please get Officer Lee? I'll need a direct number for him to call you briefly.
Tak mi prosím vás dejte znova toho úředníka, ano?
Say again, sorry.
Good morning, Officer Lee. I'm wondering if I can have a direct number to call you so I can, I'm not sure how that's going to work with the interpreter. Oh, I see. Mr. Lee, am I able to get a direct contact number for you so I can speak with Mr. Vlcek?
Yeah, stand by.
Sorry.
Okay.
Okay.
Right, good morning, everyone. The Court of Appeal for Bermuda has now convened on the 3rd of March, 2022 for the hearing of criminal appeal number 6 of 2021, Josef Vlcek against the Queen. Mr. Vlcek is being represented by Ms. Orly Cassidy, and the Director for Public Prosecutions is representing the respondent. These proceedings are taken before my Lord the President, Sir Christopher Clark, Justice of Appeal Jeffrey Bell, and Dame Elizabeth Gloucester, Justice of Appeal.
Takže teďka probíhá soudní odvolání. Sorry, I do apologize. So, dneska takže probíhá odvolání a je to 3.3. v roce 2002.
As those of you who are present in court can see, they're sitting in a rather unusual way, one off to the left, one off to the right, and nobody in the middle. The way which the system appears to work is that if those who are appearing remotely are not muted here, when you
Christopher, we can't hear you.
Know that. Can you hear me now? Right.
Yes.
I'll start again. The position in relation to this system is that if those who are participating remotely, that is to say, Mr. Vlcek, the interpreter, and Justice Gloucester, are not muted, if they are not muted, when counsel speak to us, we hear both counsel and an echo in the microphone, in the speaker that is here, which is incredibly distracting. So that the way in which we have proceeded so far in court is that I will mute those who are listening remotely. That means that if they speak, they won't be able to be heard here until I unmute them. I'm afraid it's not an ideal system, but that's the only way in which we think that we can proceed, because it's a terrible distraction to hear counsel twice, as it were. But what that means is that if, for instance, the interpreter wishes me to slow down, or if Justice Gloucester wishes to say something, it will be necessary to indicate some way by hand that that is what is wanted. And then I will unmute the remote participants. It's not ideal, but there's no other way of going about it. So that's what I'm going to do now. Hopefully, I'm muting the remote participants and not myself. Right. Yes.
Good morning, my lord. Good morning, my lord and ladies.
You've got to speak up, Miss Cassidy. I can't hear you.
Yes, thank you, my lords and lady. My lord, I'm just concerned that if the interpreter is muted, that Mr. Vlcek will not be able to hear her translating.
Right.
I'm not certain she's on the phone. That was if there was a query.
You really have to do much better with your voice, I'm afraid, Miss Cassidy. I have the difficulty hearing you. And stand closer to the mic if you would.
I'm guided. My lord.
Can I ask the interpreter, if I mute you, can Mr. Vlcek hear you?
Your Honor, if you mute me, he will not be able to hear me. But as we did it previously at the previous hearing, I've been called on my mobile, and I was speaking to my mobile, which was connected to Mr. Vlcek. So I could speak, and he will be able to hear me. He will be muted, so I will not hear the court proceedings from his room. I'll be only listening to your proceedings remotely, and I will be muted for your hearing. That's how we did it previous time, and that worked.
Sorry, can I understand that? So are you saying that you will communicate with him remotely on your mobile?
Yes, somebody has to call me on my mobile, and I will be able to speak with him via my mobile phone while I'm listening to the court proceedings, but I will be muted for the court proceedings.
Sorry, I'm not following this. Somebody has to call you. Who has to call you on your mobile?
Last time it was Mr. Kuala who was dialing my number, and he was connecting me to the prison.
But in what circumstances does Mr. Coelho need to call you?
Well, previously we did that. He was just dialing my number and he connected me to the prison. Maybe Mr. Kuala can assist?
No, Ms. Contractor, the prison officer that is in the room with Mr. Vlcek presently needs to contact you directly so that you two can speak with each other over the phone whilst your mics are muted. So could the prison officer who is present with Mr. Vlcek confirm that he has been able to reach you? I see his phone up to his ear.
I am not receiving any phone call at the moment at all.
I am dialing the number.
All right.
But
Já vás slyším, paní překladatelko.
Já vás taky. Domluváme se jenom, jakým způsobem se spojíme my dva. Sorry, I'm just explaining that we are trying to connect by phone.
Děkuju a řekněte soudu, že slušně, že říkám dobrý den slušně.
I would like to say hello to all the court.
Ms. Vlcek, I'm sorry, Ms. Contractor,
Mhm.
could you send me an email with your telephone number?
Of course, I will do so immediately.
Thank you.
I will write that.
Když mluvíte vy, paní překladatelko, já vás slyším, ale když mluví pan soudce, já ho neslyším.
Thank you, I've received it.
Right.
That's what I'm doing now.
No. I mean, well, this is it, right? But she says it's +44 and then that number.
So, Dio Lee, I've just sent you an email with the format as to how the number is to be dialed. So just dial it as written.
Okay.
And I'm assuming you're dialing her by regular phone and not WhatsApp.
Yes, a regular phone. I haven't received your email yet. I'm still waiting for it. Already. Yeah.
Did you receive the email?
Yes, I have. Thank you very much, sir.
And are you connected?
We're dialing now.
Okay.
Yeah. Okay, I believe we are connected.
Excellent, thank you. My Lord President, reissue your direction.
Well, wait a minute. Has the interpreter been connected by phone?
Yes.
Yes?
Ms. Contractor, can you confirm that you have connected by phone?
Yes, I'm now connected, but I will need Mr. Vlcek to mute the court proceedings as is echoing. Thank you.
Right. Mute those who are participating remotely. Right. Yes.
Good morning, my lords and my lady. So my lord, there is the application of which I understand was granted to extend the time of which to file the appeal.
Yes, you've done that.
I'm grateful, my lord. So the next step,
I do apologize, but Mr. Vlcek has got the sound on and I can hear myself interpreting from his room.
I'm sorry, can you say?
I need in the prison to mute the court proceedings on Mr. Vlcek's side, so I don't hear it on my phone and also on the computer.
Right.
I'm sorry, I don't understand.
Yeah, no, corrections need to mute their phones so that the interpreter doesn't get the same problem that we have.
I think they've done that.
Pane Vlček, počkejte.
Okay.
You are now muted, interpreter.
Yes, I was just trying to see if Mr. Vlcek can hear me, if I'm muted on the computer.
Yeah, we have us as muted.
Right,
But I can hear, it's fine.
But can
So
Mr.
far.
Vlcek hear the interpreter?
yes.
You can. Yeah, right. Okay. And another again. Yes.
I'm most grateful, my lord. So my lord, there was also an application to amend the grounds of appeal that had been filed previously
Yes.
against conviction and sentence.
Yes, we can do that.
Yes, please, my lord. So, my lord, with regards to the initial intention for the notice of intention to appeal that was filed within a very short time between conviction and sentence. My lords, do you have my application that was filed on the 4th of February?
Yes, I do. One of the problems in this case is that there are many documents that are filed, both by former counsel Ms. Mulligan and Ms. Clark by the Director's Office, which don't have a date on the document. But I have the document of the 4th of February, which Ms. Cassidy is referring to.
Yes.
Great, thank you. So my lords and lady, the drafted notice of intention to appeal was filed by the applicant originally through his former counsel, having done so without having the benefit of taking full instructions by the appellant, and before the appellant was able to have the full benefit of an interpreter. The interpreter was made available for one additional day after the court proceedings had completed. And this was the day that the previous counsel, Ms. Mulligan, had met with the appellant at the Westgate Correctional Facility. And my friend, Mrs. Mulligan, had drafted that document without the ability to speak to Mr. Vlcek. And that document was signed and dated the 14th of March, 2019. It was on this date that Ms. Mulligan was able to have the drafted document confirmed and signed. The appellant, having now had the benefit of an interpreter.
Ms. Cassidy, we can read it, and indeed we have read it. I mean, if you're simply going to read the document, it's a bit of a redundant exercise. If you've got anything to say in relation to it, you should do so.
I'm most grateful. Thank you, my lord. My lord, the main gist of the application is, in essence, that the applicant or the appellant's English ability has frustrated the ability for not only Ms. Mulligan as trial counsel, but previous counsel before that to take proper instruction and, in essence, be able to properly prepare and draft documents. I understand that it was even of some difficulty for these courts to obtain an interpreter to ensure that these proceedings were able to proceed. And my lord, we are most grateful for the court's indulgence and assistance with having the use of Ms. Contractor to ensure we were able to file these documents within a timely manner. So my lord, the reason we have sought leave to amend the grounds of appeal is that subsequent to reviewing the original document from 2019 and the
I'm not fully getting questions. We really need to have the grounds of appeal. Do we really need to go into why we need to do it in the first place?
No, my lord, I'm grateful.
Right.
So my lords and lady, if I may now move to the submissions on behalf of the appellant. I'm most grateful. My lords and lady, the appellant is a foreign national. There is no dispute that he is a Czech national. And my lords and lady, he was offered the assistance of what was understood to be a suitable local Czech interpreter, being a veterinarian available in the islands of Bermuda. And my lord, that was when the appellant was first tasked at the Bermuda Police Services Station.
Sorry, first what?
When he was first tasked with customs, and my instructions were that there was no Czech interpreter available.
Right.
And that he had answered the questions as best he understood them. And then when he was addressed by Bermuda Police Service whilst in custody, he was then afforded a Czech national
Right.
to assist him with the police interview.
Right.
Now, my lords, I do set out the case information that is not dispute, which is summarized between paragraphs 1 through to 18. If I can move on to the first round of appeal, which relates to the appeal against conviction. And this appeal ground starts at paragraph 19 of my skeletal submissions. I'm grateful. My lords and lady, this ground is based primarily on the basis of an unfair trial and the right to adequate time and facilities. This ground of appeal covers several aspects of the appellant's afforded fundamental rights and the Bermuda Constitution order with regards specifically to Section 6, whereby the accused is granted the right to all persons charged with a criminal offense to a fair hearing within a reasonable time before an independent and impartial court. The issue primarily for this appellant is the ability to adequately prepare his case. Where a person is charged with an offense, they are entitled to know all of the evidence before them and the ability to properly and clearly communicate with their counsel to ensure equality in arms. My lords and lady, it's our respectful submission that this was not an opportunity that was properly afforded to Mr. Vlcek.
Ms. Cassidy, so we understand. Mr. Vlcek said on 2 occasions that his ability to speak the English language was about 75%. He said that to the customs officer at the airport. He said that in the police interview. So do you accept that he has that level of understanding of the English language?
My lord, my understanding from the indications that were given by Mr. Vlcek was that would have been in common circumstances. It had, in common circumstances, not in relation to legal ease and the stress and the endurance of attending to the customs officer as well as a police interview. it's a well-established fact that one may have very easy lay use of a language, but the ability to understand legal and technical terms and one's ability to understand the information being given to them in a foreign
What are the
language.
legal and technical terms which were raised? Because he had significant communication with the customs officer at the airport when he was first questioned, and he answered apparently without difficulty. And it was not until after he had been cautioned and was asked whether he understood the caution, he responded, according to the evidence, that he understood 75% of it. And he said much the same when he was being questioned by the police in the police interview, which we have tab 11 of the binder. So I just, since he had said this on 2 occasions, I want to understand whether you accept that he had a 75% grasp of the English language.
My lord, with respect, I do not.
Sorry?
I do not accept that he,
Then why did you say it? Do you say that he did not say it?
my lord, I'm not saying he did not say it. What I can indicate to my lords and lady is that my efforts to communicate with Mr. Vlcek about some very basic items and using words like disclosures and interview and caution created what is colloquially known as a blank look. And then having the interpreter then clarify and explain and go on.
I mean, the caution was in fairly standard terms. You are not obliged to say anything. And if you do say anything, it'll be recorded and maybe given in evidence.
Yes, my lord. And Mr. Vlcek, in his evidence on the stand, did indicate that he didn't understand that he had the right to silence until sometime into the interview.
He said, you say he didn't understand he had the right to silence?
He did indicate that throughout the interview.
He declined to answer questions. That's correct, isn't it?
I will agree in part, my lord. And
Sorry?
I will agree in part because the reason being is that the integrity of the interview has also been questioned. And my lords, the reason the integrity of the interview has been questioned is on 2 parts. One is the ability of the interpreter to have adequately followed what is the universal guidelines and conduct of an interpreter, which is to interpret the English, we say to Czech, and the Czech response to English. And we say most of that interview was not interpreted. And the parts that were.
Most of the interview was not interpreted, and Mr. Vlcek would be perfectly capable of answering in English questions asked of him in English. From time to time, he needed the interpreter, and when he needed the interpreter, he got the interpreter's assistance. But for most of the time, he spoke in English.
Yes, my lord. And the issue that is taken is that from the initial outset at customs,
Sorry, please speak up.
the customs officer themselves did indicate that with a foreign national, there was some communication difficulties. That was accepted. And that's the reason the
That's
police.
why I asked you whether you accepted what he had said to them of having 75% proficiency in English. But I mean, do you have the record of the police interview?
Crave your indulgence, my lord.
It's 195.
I crave your indulgence, my lord.
just while you're doing that, by way of example, I'd like you to go to page 223 of the record. Do you have that?
Yes, thank you, my lord.
Right. At line 18, this is, if one goes to the top of the page, he was being asked about fingerprints, which were on the packages which had been found in the luggage he had brought through customs. At line 12, he says, because I don't know that, maybe when we open it at this airport, maybe could be then because we, 3 persons checking, and maybe I touch it, but I don't think so. Then at line 18, and the reason I draw attention to this particular part is it's an extensive answer. He says, but don't remember that. But we everybody, 3 person check out because somebody opened it and he thinks, oh, it's a bomb, of course, in this 3 person. And after he checking, and maybe I touch, but not this package. Some of this case I touch, of course, in this open, but not this package, because these people told me don't touch it. And I mean, it could happen, only maybe on this small case, because I don't think so, because I don't touch it. I think there's cameras there. Everything must be on that camera. When we open it, it was 3 persons around. And because I think these people joking, because when I go through it again, they told me, take all stuff out of your case. And I do it. And I think it's joke because nothing inside. After these people saw something inside. But I see nothing there, you know. And after they found some very tiny stuff in place, which I really don't know so exist in this case. Now, the English is, of course, not perfect, but that's quite an extensive passage, is it not?
Yes, my lord.
Right.
My lord, the further issue with regards to the interpreter was a concern with regards to what was being interpreted and whether that was
We're
constituted.
talking about the interpreter at the time of the police interview.
Yes, my lord.
Yes.
There's no complaint about the capacity of the interpreter at trial.
But the problem that we have, as I'm sure you might have, and you will obviously have watched the video record of that interview, that when Mr. Vlcek and the interpreter, Mr. Heinz, communicate, they do so in Czech, and there's no way for us to know what was said between the 2 of them.
Yes, my lord, and that was part of trial counsel's complaint, was that there was inadequate time to allow for what was said to be interpreted, to clarify what was said, to see if the interpreter had stepped beyond the appropriate realms of strictly interpreting the English to Czech.
Most of the record here of the interview is in English. The communications between Mr. Vlcek and Mr. Heinz are not transcribed and they're not detailed. Obviously, there were some, but relatively few, and it's all in English. And the transcription of the interview is accurate. Do you agree with that? I've listened, as I'm sure my colleagues have. I've watched the interview and with the record of the interview in hand, and it seems to me to be an accurate record of what took place.
My lord, without the interpretation of what the Czech interpreter said, I can't state for certain.
But most of the time, Mr. Vlcek didn't need the services of the Czech interpreter. He was asked questions in English and he responded in English. And one can see that.
I will have seen the video, listen to it with the transcript of it in front of me. And 2 things are apparent. the occasions when the interviewer, the occasions when the interpreter translated were very yes.
You're muted.
You're muted.
I do apologize, Your Honor. I do struggle to hear you when you speak. I trouble to hear you.
Yeah. Can you hear me now?
It's not as clear as when the other judge is talking and Ms. Cassidy. I can hear everybody else very clearly. I just struggle to hear you a little
everybody?
bit.
Who don't you hear?
She doesn't hear me.
I don't hear the judge number one.
You're not.
Currently speaking, yes, you. I do apologize.
Well, that's nothing to apologize for, but. I don't know what to do about this.
Mr. President, you're very, very quiet. That's the problem. I think it's simply you're either not close enough to the microphone or it's not switched up enough. I'm having the same problem.
Well, we'll have to fix it.
Grateful.
Could I ask Justice Gloucester whether she's able to hear me when I speak? Or do you have the same problem for me as Sir Christopher?
No, you're better. Much better. I don't know about Madam Interpreter, but I can hear Justice Bell much better.
And no doubt it's the machines.
Yes, I agree with that.
Is that on? Is that any better?
Not much, no.
Is that any better?
Yes, that's much better for me.
Much better for me too. Thank you.
Right,
I'm grateful.
okay, well, they've done the necessary on my machine. I'll start where I was before. Ms. Cassidy, what I was saying, was that, like Justice Bell, I have seen the video of the interview, and I had the transcript in front of me. It seemed to me apparent that the English that was spoken has been entirely accurately recorded. And the number of occasions when the translator translated were few and far between. I've actually made a note of it on the record of interview, but they are pretty rare. So there seems to be no, it is plain that the record of interview that we have accurately sets out the English answers that were given. Now, in relation to the translation, we cannot tell whether on those limited occasions when translation took place, the translator inaccurately translated what Mr. Vlcek was saying. But on the material presently in front of us, we have no basis on which to infer or find that there was any mistranslation. And you are not, as I understand it, able, despite having had the assistance of a Czech interpreter, to indicate any respect in which the vet who interpreted did not do it correctly.
My lord, in the absence of the confirmation that it was
Sorry,
accurate,
in the absence of what?
in the absence of a confirmation of what was actually translated, I cannot state that it was accurately translated.
No, but you can't say that it was inaccurately translated either.
Let's be clear, Ms. Cassidy, that there's nothing in this record of interview where there was an answer given in Czech that was then interpreted to English. There are a number of occasions when Mr. Vlcek spoke with Mr. Hines, and their conversation in Czech, unsurprisingly, does not feature on the transcription. But following those conversations, Mr. Vlcek responded to the question in English. Let me give you an example. If you go to page 211, at line 40, the police officer says, at the end of a fairly long question, are you a drug mule? Mr. Hines says, can I just translate? And there's some conversation then takes place between Mr. Vlcek and Mr. Hines. The officer says, yes, please. Do you wish to comment? On this occasion, I should say Dr. Hines says that he was saving for a long time and wants to find a place to live. Is he aware, asked the police officer, that he needs a work permit to work in Bermuda? Dr. Hines, he wasn't aware, he wanted to find out. So he did not research before he came to Bermuda. Dr. Hines, he did not. And then there's one more comment from Dr. Hines. He thought there might be some small jobs that might be not included, you know, that he would be allowed. And then when matters resume, it's Mr. Vlcek answering questions which are put to him in English, and his answers are in English. What kind of money do we use in Bermuda? I don't know, I think dollars. Do you have any family, wife and children? No. It shows that you entered Tanzania. Yes, is that correct? Yes, yes, so on and so forth. So after the communication between Vlcek and Dr. Hines, the question and answer in English resumes. But are you able, is there any part of what Mr. Vlcek says in English that is recorded in this transcription that you say is inaccurate?
No, my lord.
No.
The issue is what was actually said in Czech by the interpreter to Mr. Vlcek.
But you can't point to any particular instance in which the interpreter interpreted something into Czech wrongly.
That is the issue, my lord.
When you said the issue,
It is the issue. Because, I'm sorry, my lord.
assume that the issue is whether the interpretation was correct. It's your appeal. If you seek to persuade us that the appeal should be allowed because the interpretation was incorrect, you have to point to a question or an answer which was incorrectly interpreted from English into Czech or from Czech into English. You can't.
No, my lord. The issue that the appellant is taking is that
Sorry, speak up.
the issue the appellant is taking is that not only the customs officer, but the police had sought the services of an interpreter, and the interpreter was present, but was not interpreting. And
Sorry,
the reason
sorry,
we-
let's pause there. The interpreter was present but was not interpreting.
Yes, my lord.
Well, that's correct, because Mr. Vlcek was being asked questions by the police officers in English and was responding in English, which.
And he never said, I don't want to speak in English. I want all the questions to be translated in Czech, and I will respond in Czech, and you can have the translation from the Czech. You never said that.
My lord, my understanding of the purpose of the interpreter was to interpret the English to Czech,
Yes.
to safeguard the process and ensure Mr. Vlcek understood exactly what was being asked of him and was able to respond in his native tongue to safeguard the process. And we respectfully complained that that was not done except for on sparring occasions.
But wait a minute. Of course, if one is dealing with somebody in a foreign language, it is necessary to make available an interpreter if he requires it or needs it.
Yes.
That is exactly what happened here. Mr. Vlcek could have said, I am not going to say anything in English. But not surprisingly, he didn't, since he speaks 75% English. He answered questions in English for most of the time. And when he thought he needed an interpreter, he got one. Now, what's wrong with that?
My lord, the issue being taken is that this is a foreign national attempting to speak what we call Queen's English and doing his best to answer questions in a stressful situation.
In what?
In a stressful situation. The concern of the appellant is that having been afforded an interpreter, he was not able to fully use the interpreter.
When you say he was not able fully to use it, all he had to do was to say, all he had to do was to say, I want that question, or all questions, translated into Czech, as he did on some occasions. But he didn't do that.
I do accept that he did not do that.
So I'm still struggling to understand what it is that Dr. Heinz may have translated inaccurately that might have affected the answers that your client gave in English.
My lord, I don't have that information. And that is the issue. That is information that ought to have been, I'm sorry. My lord.
So you people saying that is the issue. But what I need assistance on is, what are you saying? Are you saying that, what are you saying in relation to this as a ground of appeal?
Yes, my lord. What I am saying is that with the lack of clarity as to what the exact translation was with Dr. Heinz.
I'm sorry.
It's unclear as to whether Dr. Heinz was actually, in essence, giving legal advice.
Well, I mean, you
coaching.
can't, with respect, if you're suggesting that Dr. Heinz was giving legal advice, which would be extraordinary since he's a veterinarian, and Mr. Vlcek had his Bermudian lawyer there. So we are quite unable to tell from this transcription in English whether Dr. Heinz may indeed have purported to give advice to Mr. Vlcek in Czech, because there's no translation of the Czech, understandably so.
And what sort of advice is it suggested that he gave?
In essence, to say nothing.
All right.
Sorry?
Right, to say nothing. But again, my lord, that is not his position. His position is to interpret the English to Czech and the Czech to English.
So you say that Dr. Heinz advised Mr. Vlcek to say nothing, and that was clearly advice that Mr. Vlcek chose to ignore.
On some occasions, yes, my lord.
Not just on some occasions. We've got
But again,
Just a minute.
I'm sorry.
we've got 30 plus pages of interview, virtually all of which involves questions in English from the police and answers in English from Mr. Vlcek. And as I pointed out already, not surprisingly, those exchanges which Mr. Vlcek and Dr. Heinz had are not recorded. Because the person transcribing didn't understand Czech.
Yes, my lord.
And I mean, if you go, for instance, to page 213 of the record, the third line down, the police officer said, here's an easier one. How much did you pay for your plane ticket to Bermuda? To which Mr. Vlcek, and there wasn't any translation, says, either way, says, I think I better be quiet. He then asks, where did you keep the money that you used to pay for these items? You understand the question? I just want to make sure. Answer, yeah. Then the police officer says, okay. And then Mr. Vlcek says, in English, I think that I'd be quiet. And then a little later down, he's asked, did you keep any in the bank? Answer, no, always cash. And then he says, I think better quiet. None of that involved translation by the interpreter. Mr. Vlcek was exercising the right, which he plainly had, and which he plainly understood that he had, not to say anything. And even if it had been the case, for which there's no evidence, that the interpreter had said, I think they're silent. Mr. Vlcek can't have been prejudiced by being silent because he was invited to be silent.
And indeed was.
And he was. And no inference could be drawn against him because he was silent. The advice is given by him.
Understandably, my lord, but it was improper for an interview, for an interpreter.
I'm sorry, I have to ask you to repeat it.
I'm sorry, my lord, but it would be improper for the interpreter in an interview to do anything more than strictly
Well,
interpret.
we understand that, but neither do we understand that the interpreter did anything but translate accurately for Mr. Vlcek. And since we don't have a transcription of the conversations between Mr. Vlcek and the interpreter in Czech, we really can't take that any further, can we?
I'm guided, my lord.
But
I'm guided, and the reason I'm guided is because my friend, Ms. Mulligan, had sought before the trial proceeded to allow for the interpreter, the court-provided interpreter, to interpret the interview and go through it with Mr. Vlcek. Before the trial started, Mr. Vlcek hadn't even had the opportunity to view the interview in full. So that is part of one
that
complaint.
doesn't make much sense because counsel certainly had the disc of the interview and had more than enough time to review that with Mr. Vlcek.
The issue is the language barrier, my lord, and the fact that
What do you mean by that?
the court interpreter was provided.
Sorry, are we talking the court proceedings or the interview?
The interview before being admitted into the court proceedings. One of the complaints about the interview was that my friend, Ms. Mulligan, was unable to view the interview with the interpreter, who was provided days before a court hearing, and was trying to go through the evidence. So before the trial started, before the Honorable Justice, Mr. Graves, Mr. Vlcek, while having the documents for a number of years and having counsel, neither counsel speaking Czech or having the ability to use an interpreter, were not able to then do that before the information was put before the jury.
Well, please assume that is so. You presumably seen the disc.
I have not, my lord. I have access to the recording online, but I've not been able to play it. I have reviewed the transcript.
So you've got access to the recording, but you haven't been able to play it.
Yes, my lord.
Why haven't you been able to play it?
It hasn't worked on the technology that I have.
Ms. Cassidy, I was given a disc. I'm not an IT whiz. I found that I could listen to 20 minutes of it and it stopped. I contacted the DPP's office and went there and listened to it there, something which, with respect, you might have been able to do.
Yes, my lord. And with that regard, the ability to turn these submissions around within a very tight timeline has been adhered to. I have been able to review the actual written transcript, the written documents, and the trial file that had been provided by my friend, Ms. Mulligan.
Well, just in relation to the interview, you've obviously read that.
Yes,
Both of the judges, and I'm sure the same goes for Justice Gloucester, have watched the interview with the transcript in front of them and can assure you that the transcript is accurate.
I'm guided, my lord. I'm not disputing the accuracy of the transcript
Right.
in English.
So
It's the,
you don't dispute the accuracy of the transcript.
no, my lord, it's the issue of what was said in Czech and the fact that there was the.
I don't understand the relevance of what was said in Czech. Because it isn't transcribed.
Mhm.
Those of us who watched the disc don't speak Czech, so we don't know what is said between Mr. Vlcek and Dr. Heinz, and indeed there's no reason why we should.
In order to make the point good, you would have to get the interpreter, this is Czech, the interpreter, to indicate that there was any mistranslation.
Yes, my lord.
What are you suggesting that we should do? You're saying that we should allow the appeal on the grounds that there may have been a mistranslation of which we have no evidence, or selected rather small passages in the interview. Is that the solution?
I don't understand that to be the submission because I have a note that you don't understand. You don't dispute the accuracy of the transcript. So what you do say is that the comments made in the Czech language between Mr. Vlcek and Dr. Heinz are what?
That's the issue, is I don't
What-
know,
what
I
is the
don't know
issue?
what they are.
Sorry?
Other than Mr. Vlcek has indicated that he was being given advice. So it was being,
What is the proposition? That because Mr. Vlcek has said that he was being given advice, by the interpreter, though it's not apparent, A, whether he was, B, what the advice was. On that ground alone, we should allow the appeal.
no, my lord, that it actually forms part of the appeal nexus because the interview is then relied upon by the jury.
Yes.
And with the question about what advice or what information was interpreted to Mr. Vlcek, it questioned, I say, the integrity of the interview.
So what?
So it would be unreliable.
What is unreliable?
Is
What is it that you say is unreliable?
the information that was provided to Mr. Vlcek during.
But you don't know what it is. You've already told us you don't know what it is because you haven't had that interpreted. So all we have is Mr. Vlcek's statement that he was being given advice by Dr. Heinz.
Yes, my lord.
And we don't know what that advice was, save that you said earlier, in essence, Dr. Heinz told Mr. Vlcek that he should not say anything,
Yes, my lord.
a right which he exercised from time to time.
Yes, my lord.
So what is the problem with that?
The problem is that is not the function of the interpreter in an interview or in their capacity.
That doesn't make the trial bad. The fact of it is that the interview as transcribed, most of which involves Mr. Vlcek's statement in English, you have confirmed is accurate.
Yes, my lord. So the English version is not what is in question. It's the
Sorry?
Czech. The English version is not what is being questioned. It's the Czech.
What's been
interpretation.
questioned is the fact that there were some communications in Czech between Mr. Vlcek and the interpreter, who was not a trained interpreter, and you say he went beyond the task of translating from Czech to English and English to Czech.
Yes, my lord.
Well, so yes, but were you also saying that he mistranslated something or not?
So what my instructions are is that Dr. Hines did not understand some of the English that he was being asked to translate.
But the problem that you have with that submission is that you actually can't make it good because you have no idea of what it is that Dr. Hines said to Mr. Vlcek and vice versa.
I'm sorry, if your instructions are Mr. Heinz did not understand some of the English, those instructions come from a man whose first language is Czech, but who appears to be sufficiently capable of understanding English to realize that the Czech speaking interpreter has got it wrong.
No, my lord, the instructions were when the Czech interpreter, Dr. Hines, was interpreting. My client's instructions are that the doctor didn't know the word to interpret it in Czech.
He did not know. In other words, Mr. Vlcek's command of the English language was greater than Dr. Heinz's. Is that what you're saying?
Yes, my lord,
No, we know that.
to a certain degree.
Just give me a moment. So how then was Mr. Vlcek prejudiced when he understood that which Dr. Hines did not understand?
My lord, that is not what my submission was. My submission was that Mr. Vlcek, my client, had indicated that there were certain words that the interpreter was unable to interpret, not that he understood what those words were.
Could I come in here, Mr. President?
Sorry, I'm
please?
giving complete, oh, sorry.
And Mr. Justice,
Yes. Justice
May I
Walker?
come in?
Yes, well,
Again, I'd just like to clarify, please, precisely what the submission is here. Is the submission that Dr. Heinz did not accurately or completely translate from English into Czech what was being said in court?
Thank you, my
And
lady.
is it that Dr. Heinz did not accurately translate from Czech into English what Mr. Vlcek was saying in response? Is it both of those things or just the first?
My lady, if I can clarify, in terms of the Dr. Hines, he was only the interpreter at the
sorry,
police station.
you'll have to start again. There was an echo when you started. So
I'm most grateful.
take it
my
slowly
lady.
because
Yes. So, my lady, if I can clarify, the Dr. Hines only provided the interpretation.
Dr. Heinz, what?
Dr. Hines provided the interpretation services at the police station only.
Well, just starting there, that's not true. Dr. Heinz did not say a single word for the first however many pages it is. I made a note of the first time that there was discussion between Dr. Heinz and Mr. Vlcek. All of these answers that Mr. Vlcek gave, he gave in English to a question asked in English. The interpreter was not interpreting every question into Czech, and Mr. Vlcek was not answering in Czech. So
I apologize, my lord. No, I'm not suggesting that the entire interview was interpreted.
no, but
my
you said
lady-
that
I'm sorry, my lady just,
I'm very sorry, but I am getting completely lost in what your submission is. I quite follow that there's no complaint about the interpretation of trial. I quite follow that you accept that the record of interview accurately sets out what was said in English. But I want you, with complete clarity, to tell me so that I can make a careful note, what exactly is your complaint about what happened so far as the interpreter was concerned at the interview with the police?
And I hope this
Don't
does.
tell me that something's an issue, simply tell me what you say went wrong.
Yes, my lord. The interview, we say with the police, ought to have been conducted using strictly the Czech interpreter.
So, sorry. Wait, the interview ought to have been conducted entirely in Czech.
So the Czech interpreter interpreted the English to Czech and the Czech to English.
So with every question in English being interpreted into Czech, Mr. Vlcek giving his answers in Czech, and Dr. Heitz translating. That's what you say should have happened?
Yes, my lord.
That's what you say should have happened. That's not what did happen, or which Mr. Vlcek asked to happen. But what, if anything, you say went wrong with the interpretation that actually took place?
My lord, the issue of the interpretation being completely exactly what was said by the police officers.
I'm sorry.
No.
I didn't hear. Could you start that sentence again?
Yes, my lord. So the interpretation from English to Czech and the fact that the interpreter did not just strictly
The
conduct,
interpreter was not just what?
he did not just strictly provide an interpretation.
Well, he didn't, as I've demonstrated, if you start at the beginning of the interview, everything is in English. The interpreter was not asked to translate from English to Czech and Czech to English, and didn't do so. The first note that I have of discussion between Mr. Vlcek and Dr. Heitz was on page 201, where Mr. Vlcek had said that he didn't understand clearly. And at that point, there was extensive discussion between Mr. Vlcek and Dr. Heitz in Czech before Dr. Heitz says at line 24, okay, yeah, he said he didn't want to get anybody else involved. And he also said that he didn't put the drugs in the case and he absolutely hated drugs, hates drugs. Yeah, so that is a statement in English made by Dr. Heitz, supposedly reflecting what Mr. Vlcek had said to him. But up until that point, all of the communications had been questions in English, responses in English. So, but you say that shouldn't have happened, despite the fact that Mr. Vlcek never asked that they be translated. He was asked questions in English, he responded in English. On matters that were quite important to the outcome of the case, because he gave a version of events as to where he had bought the suitcases which were brought into Bermuda, which was inconsistent with the evidence he then gave at trial. And there's no question of interpretation of those or translation of those. He was asked a question in English and he answered in English. Where did you buy it? I'm at page 200. At the market. What's the name of the market? I'm not sure because I travel and I buy it at store. And then at the bottom of the page, what part of London is it? Is it UK? Yes, it's East London at a market. So you're saying that when you bought the suitcases, they were like, they seemed normal. It was absolutely normal, and so on and so forth. Now, this is all in English. Mr. Vlcek hasn't asked that the question be translated into Czech before he responds. He said to the customs officer that he's 75% fluent in English. He said at the end of the police interview that he's 70%. So why should question and answer be translated Czech, English, English, Czech if Mr. Vlcek hasn't requested that that should happen?
My lord, to safeguard the use of that evidence in proceedings,
To safeguard what?
that use of evidence in proceedings.
What do you mean by that?
So, my lord, because it arose questions with the defense counsel, Ms. Mulligan, as to the integrity of the interview on the primary basis of
I don't
one.
understand. You use phrases like the integrity of the interview. We've already established that the transcription of the interview is correct
In English,
in English.
right.
So
So there was
what do you mean by the integrity of the interview?
the issue of what was said in Czech.
But what relevance does that have when Mr. Vlcek gave answers in English? We have your point that there was discussion between Mr. Vlcek and Dr. Heinz in Czech. We know that from having listened to the video of the interview. I still don't understand what it is. What is the relevance of what was said in Czech between Dr. Heinz and Mr. Vlcek?
My lord, it's a complaint of whether, in essence, legal advice or a discussion of what he should say, and whether the interpreter did understand some of the items that were being interpreted. And these were issues that should have been addressed before the matter proceeded to trial, which they didn't.
Well, these were issues that should have been addressed, but the police interview took place some considerable time before the trial.
And an interpreter was provided days before the trial.
And when the trial started, there was an application made to that the evidence of the police interview should be excluded, and the judge rejected that.
Yes, my lord.
I'm sorry, I'm going back to where I was before. I really want to make a clear note of what exactly it is you say. What I understand you to say is that the interview ought to have been conducted entirely in Czech. That is to say, with the questions being translated into Czech, the answers being given in Czech and translated into English. Is that right?
Yes.
Yes, my lord.
Wait, take it in stages. That's item number one. You also, and would appear to have the consequence that would have to take place in relation to every non-English speaker.
That's quite a note.
But I think you also have a complaint about, as I understand it, about how the interpretation went wrong on occasion. Is that right?
Yes, my lord.
Well, I don't understand that to be the case.
Well, that's why I'm asking the question.
Because you've said that what we see in the transcript is accurate.
In
No,
English.
wait a minute. What we see in the transcript is the English. What I think you're saying is that the interpretation from English into Czech when it took place, or from Czech into English when it took place, somehow went wrong.
Yes, but that's why I put to Miss Cassidy that she couldn't speak to that. Since
I
yes.
know.
Yeah.
Sorry,
I'll leave
this in stages. You, as I understand it, you said that something went wrong with the translation from English into Czech or from Czech into English, but we don't know what it is.
Yes, my lord.
And you don't know either,
No, my lord.
right? And lastly, you say that on occasion, the interpreter gave what you characterized as legal advice, namely not to say anything.
Yes, my lord.
And we don't know whether he said that either. But we do know that without interpretation, Mr. Vlcek decided not to say anything on quite a number of occasions.
Yes, my lord.
Right. And you say on account of those defects, what do you say? That the conviction is unsafe?
Yes, my lord.
Right. Thank you.
Mr. President, can I come in
My lord,
with a
also
question?
under
Miss
that,
Gloucester, Justice Gloucester has a question.
Yes.
Miss Cassidy, I'm just trying to understand your submissions. Would it not be possible for you to give us an example on Mr. Vlcek's instructions as to when there was an error in the translation services being provided, or when there was a concern by Mr. Vlcek that he was being given advice to say nothing, and he did so as a result? It's very difficult to see how your submissions play out unless you can give us one or two examples by reference to the English transcript and by reference to Mr. Vlcek's instructions of where there is an example of where things went wrong. Because reading the transcript and seeing it, it's just difficult to get a grip on that.
I'm guided, my Lady Justice. I'm not able to point to specific examples. It was just repeatedly through the instructions and going through.
Speak up, Ms. Cassidy. The acoustics are not what they used to be before we all had sheets of perspex in front of us. So please speak up.
Thank you, my lord. Thank you, my ladies. So I did seek clarity specifically with Mr. Vlcek. And he had indicated that it was.
Just a minute. Just a minute. Sorry, start again. I do apologize for that. I mean, it's our apology to you. It's less than ideal, I understand.
I did seek to clarify those instructions with Mr. Vlcek. And what he had indicated was that he frequently was, throughout the interview when there was a translation, trying to clarify what exactly it was the translator was meaning and what it was he was being asked.
But you can't point to a particular passage in the interview where that occurred.
No, my lord, I'm afraid I didn't have sufficient time to conduct that exercise with Mr. Vlcek, adhering to the very strict timelines to file. I do apologize.
So Mr. Heinz gave evidence at the trial, didn't he?
I believe so, my lord.
Can we just have a look at the evidence that he gave? If you go to the record of appeal, page 93, well, it's not the evidence, it's the summation. The summation. The learned judge refers to, at line 4, to Yuri Heinz, the doctor. Then at 12, he said he's not a professional, this was Mr. Heinz's evidence. He's not a professional translator, but he was summoned to assist. He was given the relevant instructions, spoke with the defendant and his lawyer. He participated and he agreed to give assistance when necessary. He said the defendant spoke some English and he only assisted when he needed help. And then I can skip the next paragraph. He was cross-examined and he said he basically assisted and could determine when the assistance was needed as he sat next to the defendant, looked at him, or the defendant would look at him, and they understood when the defendant needed help. He was referred to the video and the transcript about the caution and the lawyer, and he said he did tell him that Mr. Vlcek, he can stop and speak to his lawyer for 5 minutes whenever he wishes. And if he went over, they would start over. Some other areas he was pointed to. I think they didn't add anything material to the evidence. So the picture given by the veterinarian translator was that he gave assistance when needed, and it wasn't suggested to him that he mistranslated anything or that he'd given advice that he shouldn't speak or that anything had gone wrong.
Correct, my lord.
So it's a little difficult for you to make the case of this inaccuracy when it was never put to Dr. Heinz that he failed in his duties to interpret.
Or that he'd taken upon himself something which wasn't the interpreter's fault.
I am guided, my lords. I was not trial counsel.
No, you were not. No, you were not.
I can't speak to what her instructions were on that regard. I think that would have been a salient point to have raised with Dr. Hines. It has certainly formed part of my instructions, which is why we have advanced the appeal on this aspect.
Right, well, that's ground one.
My lord, ground one does also extend into the hearing as well,
Sorry?
the fair hearing and the ability to have his trial preparation time.
Yes.
My lords, that starts at paragraph 22.
Yes.
I'm grateful.
Well, I'm sorry. It would help if you indicate what submission you're making or refer us to.
I think you said you got as far as paragraph 28,
22, my lords.
22,
Yes.
right.
So my lord, this aspect, which is part of the unfair trial ground one, is the complaint by the appellant with which he was frustrated in the ability to accurately and have sufficient time to prepare and review the full disclosure provided and fully engage with his counsel. My lords, the complaint is that he was not able to be properly present before the trial and fully engaged on the lack of ability to have an interpreter, with only having one mere days before the trial when one was flown into Bermuda by the courts.
But I struggle with the notion that Mr. Vlcek was able to have any meaningful communication with his counsel when he has given a version of events in the police interview and then chose to give a different version of events at the trial.
My lord, the complaint is that an interpreter was provided some, I believe, 19 months after he initially arrived onto this island.
Well, but my point is, surely there were in fact two other attorneys who acted before Miss Mulligan took over.
Yes, my lord.
So that, as I understand it, was Mr. Richardson and Miss Christopher, both extremely experienced defense counsel.
Yes, my lord.
Did Mr. Vlcek meet with them?
My lord, I don't have instructions on that regard.
Right.
What I do
So
have is
in any event, he changed to Miss Mulligan, his third choice of counsel, before trial. And
Yes, ma'am.
she met with him and she's made a statement as to what she says were her difficulties in relation to, she both swore an affidavit and made a statement back in October of last year. Surely, if, let's say, if Mr. Vlcek's case was, as he told the police, that he had bought this suitcase at a market, found a smaller one inside the big one, he could have told Miss Mulligan that that was his case.
Yes, my lord.
And in the event, he gave an entirely different version of events in his evidence. Did not say that he bought the case at Walthamstow, said it was given to him by two men he'd met in a pub with whom he'd had conversations about supporting his art and so on. We've got the trip to Johannesburg, where he was apparently being paid to smuggle gold and diamonds. Those are all matters that he surely had sufficient English that he could have communicated to Miss Mulligan.
I say yes and no, my lord. The issue of with a foreign national, my instructions, my attempts to communicate with Mr. Vlcek have been frustrated. He did actually seek to change to me as counsel.
He what?
He did seek to change to me as counsel, and the ability to communicate with him with the paperwork.
Well,
has
you,
been
you are his fourth counsel.
Yes.
It really doesn't sit particularly well if he makes complaints about the difficulties that he experienced when in fact there were a number of changes of counsel. But in any event, my question goes towards Miss Mulligan, who represented him at trial, and presumably she had at least had sufficient opportunity to understand what his defense was.
I believe so, my lord.
Right. So that
the issue complained of is the ability to have all of the information and the statements and the like translated to check to ensure that he understood
what
the
information?
evidence.
This is a case which turns on very few facts. The fact of it is, Mr. Vlcek did arrive in Bermuda with suitcases which had quantities of heroin hidden in the lining. That's not a matter that he disputes.
Right.
So the only question is how the heroin got there. He gave one version of events in his police interview, and he gave an entirely different version in his evidence.
Yes,
It's reasonable to suppose that he had some conversation with Miss Mulligan as to what his evidence was before he actually gave it.
yes, my lord.
Is that not the case?
That is agreed, my lord.
So he told Miss Mulligan before he gave evidence that what he had told the police was not true, and that the true version was the two men that he had met in a pub had given him a suitcase, and that he was supposed to be smuggling gold and diamonds to Bermuda. He never actually received the gold and diamonds, yet when the case was opened after the customs officers detected a bulge in the lining, he made the statement, if it's gold and diamonds, it's mine. If it's drugs, it's not. Is that not a rather extraordinary statement to make?
Yes, my lord.
In English.
Yes, my lord.
I mean, it's plain that there was a completely different account given to the police to that which was given at trial. That may have complications so far as the defense is concerned, but it seems also plain that Ms. Mulligan had received instructions in relation to the case that was put at trial, and she was perfectly able to ask him all the questions that related to that case, and he gave evidence about it in some detail, about how the suitcases were delivered to him, apparently empty, and that sort of stuff, following the meeting with the people in the pub and the gentleman, apparently a representative of the Bermuda government, who spoke to him and said that the importation of gold and diamonds to Bermuda was something to do with sport. I mean, the whole case, he'd obviously given sufficient instructions to Miss Mulligan to adduce the evidence, which she did. I can't at the moment understand what problem he faced on account of the shortness of time that he had with Miss Mulligan, so far as putting his new case was concerned.
My lord, the concern was that an interpreter was provided days before trial, and that there was additional evidence that was also adduced during trial. And that the complaint of Miss Mulligan
Miss
was,
Mulligan spent hours with him,
yes,
and she set out exactly how long she spent with him on the various days.
yes, my lord. She also spoke to the fact that they had not gotten through the entirety of the police interview before the trial proceeding, and that the court would not grant the adjournment of a short, brief period to allow them to complete the evidence and for her to complete instructions.
But the point, as I said before, in factual terms, it's a very simple case. He did arrive in Bermuda with the quantity of drugs that we know. He gave one version to the police and a different version in his evidence. And as we've established, it's reasonable to infer that he had told the true version of events, true in inverted commas, to Miss Mulligan before he actually gave evidence.
Yes, my lord.
Miss Mulligan would have been bound to point out to him that he might face some difficulty by the reason of the fact that the evidence that he gave was inconsistent with what he had said in his statement to the police.
Yes, my lord.
There it is.
My lord, the issue still remains, though, that there's a quantity of evidence that had to be interpreted to ensure she was able to take adequate instructions.
Sorry, which
Proceeding.
evidence is that?
The volume of the witness statements, the interview and the like, in addition to the additional disclosure as the trial proceeded. The concern
So
was,
we've established that the transcript of the police interview is accurate. So the only thing that we don't have and you don't have is knowledge as to the exchanges in Czech between Mr. Vlcek and Dr. Heitz.
yes, my lord.
So we're actually not able to take that aspect of matters any further because you can't help us with it through no fault of yours.
Yes, my lord. Just clarifying for the court that that was a complaint of Ms. Mulligan before the trial proceeded, that there had been inadequate time to fully go through the evidence and complete instructions before the trial proceeded.
I didn't follow it. The interview had taken place. Mr. Vlcek had been present at the interview. So he knows perfectly well what he'd said. And it's perfectly apparent that what he had said at the interview was not the case that he was putting at trial. I can't, in those circumstances, think what further assistance would have been gained by crawling through the interview to see exactly what was said and when what was going to happen at the trial was that he was going to, in effect, say, what I said in the interview was completely wrong. The true story is this. What assistance would it have been to have gone through the interview with him for hours?
My lord, it's his right as the accused.
Sorry?
It's his right as the accused to have gone through the evidence
That
completely.
That is not an answer to my question. What assistance would it have been for him to have gone through the interview with his counsel for as long as he liked?
His instructions where it frustrated his ability to complete his instructions to his counsel.
That's not an answer to my question. I asked it twice, I won't ask it again. Right, where do we go from here?
My lord, that moves, if I can move on to now paragraph 29 of that same ground. So my lord, it is quite correct that the trial judge has the authority to determine whether or not an appellant requires the assistance of an interpreter. The concern for Mr. Vlcek was that the trial judge had based his decision on one prior court appearance that he deemed the appellant to have had sufficient enough English to understand and to proceed at the trial without further delay. My lord, we rely upon the case of Adam Malophysis and Olympic Airways SA, which is a New South Wales case.
But, I mean, we have to bear in mind that Mr. Vlcek did have the services of an interpreter through trial, and
Yes, my lord.
the entire trial proceedings, as I understood it, took
Yes.
place in the manner in which you say the police interview ought properly to have taken place. Yes?
Yes, my lord.
Right. So do you want to take us to Adamopoulos?
My lord, I'm just trying to pull it up.
Well, let me just ask you, Ms. Cathy, the second sentence in paragraph 29, the trial judge had no regard for the appellant's rights to have the full and complete support of an interpreter. That's precisely what happened, that the appellant had a full and complete support of an interpreter, did he not?
No, my lord, he did not. It was during the trial. It can be heard on the recordings where the interpreter had asked the court to, with a witness to slow down. And the judge during the trial did criticize and yell at the interpreter.
Well, I appreciate that the judge made those comments when he was delivering his ruling.
Yes, my lord.
The rationale for that was clearly that Mr. Vlcek and the interpreter, and indeed counsel, could read the ruling and see what was said at some later date. And he didn't want to disrupt the trial by having sentence by sentence translation. But apart from the ruling in relation to the admissibility of the police interview, was there any other place where you say that the translator wasn't given the opportunity to translate?
Yes, my lord, my instructions are that when witnesses were giving evidence and the interpreter had asked for them to slow down, that
Where do we have that?
favor indulgence, my lord.
I haven't seen the case of that Adamopoulos. Sorry? No, it's not in mine.
There's nothing behind our intelligence.
It's something airways, something Greek.
Adamopoulos against.
Is this Adamopoulos?
Yes.
Adamopoulos.
Ms. Patton provided the transparency.
Well, I'm sorry, but these submissions were produced some days ago. Why don't we have Adamopoulos in hard copy? Mr. Quello, I need your assistance to get onto the cloud.
Yes, it is on the cloud. It's been put 3 hours.
I'm sorry, Mr. Cassidy, I don't have access to the cloud just yet. Oh, I don't need the hard copy. Is that another hard copy? Oh, so Christopher.
There you go.
That makes it a great deal easier. We now have Adamapolis in hard copy. So,
What should we look at in this?
Yes, my lord. That is located at page 77.
sorry. didn't hear.
77.
Yes, my lord. So I'm just trying to.
Right.
Sorry, what page did you say?
Justice Gloucester has a question.
What page?
77.
77.
Thank you. Okay.
Where do we start, Ms. Cassidy?
My lord, this case does differ somewhat from the case at bar, insofar as an interpreter was prohibited in the case that is at tab 20. However, it does go into
Sorry,
the
tab
print.
20.
You mean this case?
We've got hard
Yes.
copy in front of us.
I'm most grateful. So my lord, looking at,
So this is a case of a refusal to allow the assistance of an interpreter.
yes, my lord,
So it's not the same as our case.
right, but it does speak to the purposes of an interpreter.
Right.
So at page 77, midway past paragraph D, speaking to the refusal of an interpreter. So far as the refusal to allow the assistance of an interpreter is concerned, I am sympathetic to the position of the people from cultural and linguistic backgrounds who seek the assistance of an interpreter in our courts. The mere fact that a person can sufficiently speak the English language to perform mundane and social tasks or even business obligations at the person's own pace does not necessarily mean that he or she is able to cope with the added stress imposed by appearing as a witness in a court of law. Still more powerful are the reasons for affording a person with assistance of an interpreter if he or she must present a case without the help of legal counsel, which we respectfully submit Mr. Vlcek did have the assistance with. Some of the earlier legal authorities about access to an interpreter reflect the attitude of society, radically and linguistically homogeneous and often unsympathetic to the problems of others struggling in an alien environment. It is typical of a country with poor skills in language other than English that even added educated judicial officers sometimes show an intolerance to the predicament of parties and witnesses whose first language is not English and who seek the provision of an interpreter.
Well, there's all the good reasons for having an interpreter,
Yes, my lord.
but there was an interpreter. Both at the interview and at the trial.
Yes, my lord. And that's not disputed. The concern that was being raised was the ability of the interpreter to adequately interpret the information and the evidence occurring in the proceedings.
Are we talking at the trial now? or at the police interview,
My lord, we're speaking of trial at this point.
trial?
Sorry, is it suggested that at the trial, the interpreter was inadequate?
No, my
No, isn't it? No. Right.
So I don't quite understand how this case helps us. Apart from it points to the wisdom of having happened that which happened in this case, namely provision of an interpreter.
yes, my lord.
In accordance with the Constitution.
Right?
So, my lord, it's our respectful submission that whilst the appellant was present at trial, we say that he was excluded from fully participating in the proceedings through his lack of comprehension in the English language. And we say that despite his indicated 70 to 75% understanding.
Right, I see that you've moved on. I just wanted to point out an error that you make in paragraph 30, sorry, as it seems to me. You say that the trial judge criticized both defense counsel and the interpreter for interrupting him reading his ruling and qualified that the appellant need not understand his ruling. That's not what he said. What he said appears at tab 1, page 12 of the ruling. That's in the ruling bundle, and what the judge said, the interpreter said she was having a difficulty. At line 16, the court, listen, this doesn't have to be interpreted, it's a ruling. And the interpreter remonstrated, and the court said, no, I tell you what you're supposed to do, ma'am, I run the court. But he didn't say that Vlcek, Mr. Vlcek didn't need to understand his ruling. He said it didn't need to be interpreted as he gave it. There's a rather important distinction.
I'm guided, my lord. If I can make that correction.
So where next?
Well, you say in paragraph 31, in effect, that the proceedings were conducted at a more appropriate, at an inappropriate pace. And they should have been conducted in such a way that the appellant was afforded the full benefit of having a translator with him. But I haven't found the slightest suggestion at any stage in the proceedings that there was any difficulty being experienced in the process of translation by the interpreter to the defendant. Ms. Mulligan didn't get up and say, could we go more slowly?
My lord, that was my instructions from Mr. Vlcek, that the interpreter often had to stop mid-interpretation to move on to the next point to try and keep pace.
Well, we don't have a transcription of the entire evidence because that would be an unnecessary exercise, but we do have a transcription of Mr. Vlcek's evidence, and I don't see anywhere where it's suggested that that the pace was too fast for the interpreter. Can you point to anywhere where that was the case?
My lord, I did not see that vocalized in his evidence.
Right. So there's no way you can take us to, in Mr. Vlcek's evidence, where the judge was causing the pace to move too quickly.
No, my lord.
Okay. Right. Where do we get to next?
Round two, my lords. My lord, and that speaks to the complaint that the trial judge heard in law. And my lord, that speaks specifically to the police evidence that we have already discussed significantly.
Right, I think we've largely dealt with round two.
Yes, my lord. So my lord, if I can move to ground number 3, please.
Round number 3, yes.
Yes. My lord, with regards to the complaint that there was an unfair trial on the basis of the conduct of the Crown, we respectfully submit that the test is if a fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased.
Well, wait a minute. It has to be the tribunal. Tribunal here is a jury.
My lord, we're respectfully submitting that it was the trial judge,
Okay, the chief trial judge.
because
say
he's
Not Crown Counsel.
the decider of law,
Right.
and the jury would be the trier of fact. So my lord, the complaint
So-
is,
Sorry. So the trial judge was biased, you say?
yes, my lord. Appeared biased.
Why do you say he was biased?
My lord, on 2 aspects. One being his management of the court during the trial, specifically the conduct of Crown Counsel to ensure the proceedings proceeded in a fair and balanced manner. Crown Counsel can be heard on the recordings speaking specifically in the cross-examination of Mr. Vlcek in a slow, loud, derogatory manner. You can hear snickering on the
Better
recording.
take us to exactly where it is in the evidence of Mr. Vlcek's cross-examination that you take. Because it seems to me that if it could be said that Ms. Smith overstepped the mark, the judge did try to restrain it. If you look at page 32 of the evidence, when Ms. Smith interrupted, "That's not fair," Ms. Mulligan said, "If you have an objection, Ms. Smith," and there was over-speaking. Mr. Justice Graves says, "Please." And Ms. Smith said, "It sounds like she's cross-examining her own witness." And Justice Graves says, "What's the question again? Without interruption, put the question, please." So he was, as it seems to me, controlling the process. But surely you have to establish something rather more to say that there was apparent bias on the judge's part.
Well, it's not supposed to be biased because Crown Counsel overstepped the mark. The position borders on the ridiculous. I'm afraid that counsels do sometimes overstep the mark. And judges deal with them in different ways. Some think it's better to say nothing, people all go away. Some are critical, some are in between. Sorry, somebody's trying to interpret.
Yes.
I do apologize, Yona. I do struggle to hear you once again. I'm not sure if I'm the
Mm.
only one or if others have the same
Not
issue.
bad, but-
Yeah.
Sorry, what?
They can't find it. Can you hear me now?
It's not clear. No, not really.
Mr. Quillo, Mr. Mello was able to fix it previously.
I've got the same problem as Madam Interpreter.
And is it just Sir Christopher, Justice Gloucester, or is it me as well?
No, Justice Bell, you're coming over loud and clear.
Well, he fiddled around with some internal control.
And he fixed it very quickly.
Does this make any difference? Is that me? Right. Is that any better?
Oh, but we get,
Now we get this echo.
Turn down sound and leave the mic open.
What? The trouble is,
Mr. Clark is saying if you turn down the sound, you won't get the sound on the cell phone, you won't get the feedback. You want me to mute? Right. I don't think that's working. Right. Let me just. And what which is that? This? Pretty low already, Alton. Testing 1, 2, 3.
testing 1, 2, 3.
Justice Gloucester and Madam Interpreter, can you both hear Justice Bell and Justice Clark?
Yes. It's much better.
That's
Thank
better,
you.
I think.
Thank you.
But the trouble is, there's a nightmare echo.
And that as soon as you press F1, that problem's going to arise.
What I did was turn the volumes off on the laptop.
Is that?
Yeah.
What do you mean?
That's fine.
Is it?
Is that coming out of it?
That's good from the president.
You can hear me, can you? Right. Okay.
Yes. So,
Right.
Ms. Cassidy, you said that the judge was biased because he failed to control counsel.
Yes, my lord.
Porter and McGill doesn't say that, and I know of no case which does.
So, my lord, there was also the conduct of the judge during trial.
Well, that's the second point. Let's stay on the first point. How is it that you maintain that the judge can be said to be biased because he failed to control counsel, despite there being instances, one of which I've just shown you, where he was attempting to do just that on page 32 of the transcript?
My lord, there are many instances of which he did not do that, of which I can point you to the recording of the interview, which is noted as recording number 4.
I'm sorry. I'm having difficulty hearing you.
Right.
Could you start again? I do apologize.
So, my lord, in recording number 4, it was during that recording that Ms. Mulligan was continuing the evidence in chief for Mr. Vlcek.
I'm just going to have to ask President if you can press the F1 thing. I'm getting a feedback.
Yeah.
I do apologize again. Let's have another go.
Yes, my lord. At recording number 4, Mr. Vlcek.
Recording number 4?
Yes, my lord.
I'm
Where's
sorry,
that?
what does that mean, recording number
It's,
4?
it's the recording that was attached to the Court of Appeal file.
I haven't seen recording number 4, and I don't know where it is that I can find it.
Crave your indulgence, my lord.
Ms. Cassidy, are you referring to the court recordings that are on the file?
Yes.
Those recordings were only there for the purpose of the transcribers to translate
Oh.
transcribe the evidence of Mr. Vlcek
Oh, I see.
and Detective Sergeant Bagwell.
Right.
So there is a hard copy transcript that the judges have.
I see.
But I have the hard copy transcript of Mr. Vlcek's evidence and Detective Sergeant Bagwell.
As do I.
So can you take us to that part of the transcript that you say demonstrates some failing on the part of the judge?
Yes, my lord. I'm just trying to locate it in the transcript. Crave your indulgence, my lord. I had taken it straight from the recording itself. My lord, the specific issue that was being raised was that Ms. Mulligan was
I can't hear you.
unguided. My lord, the okay, if I can refer the court to page 31.
Yes.
With what was the amount at the top?
Right, so proceeding down towards the bottom. So starting at, let me see, 25, where the judge had allowed the question. The prosecutor was then heard and recorded as saying, unbelievable, unbelievable. Yeah, she's just interpreting that too. And then Ms. Mulligan is like, okay, enough, enough, enough. And then this is the Honorable Justice, Mr. Graves, responding, Madam, when I speak, you hear, when I rule, you follow. Ms. Smith's response was, yes, my lord.
Well, this all follows from an objection that Ms. Smith had made to a question Ms. Mulligan was proposing to put. Mr. Justice Graves had said at line 22 that he would allow the question. Ms. Smith kept on talking. Mr. Justice Graves repeats, I'll allow. Ms. Smith makes comments. And that led the judge to say, Madam, when I speak, you hear. When I rule, you follow. We surely can't. You complained a moment ago about bias on the part of the judge for not controlling counsel. Well, here he is controlling counsel.
So don't do that sort of thing.
This is not directed towards the appellant. And indeed, one sees Ms. Mulligan saying at 10, my lord, I'd ask that Mr. Smith refrain from making those kinds of comments. It's not appropriate. Mr. Justice Graves says yes. And then this is the passage that I referred you to before, where Justice Graves says, please. And he says, please again, what's the question? Without interruption, put the question, please. So he's telling counsel not to interrupt. So I don't, yes, understand the complaint in relation to the trial judge's comments.
With your indulgence, my lord, I'm just looking for the paragraph, the particular page, because I did record where at a specific time, the court did dismiss Ms. Mulligan's objection that Crown Counsel had an obligation to put details of the interview correctly.
Where are you reading from?
I'm just looking for that specific part of the transcript. I do apologize, my lord. Okay, my lord, I am at page 49.
Sorry?
49.
49. Okay, this is where the appellant was in cross-examination. Starting at line 6. Sorry, yes, you watched the interview.
Where?
Line 6.
Line 6.
Yes,
You watched the interview?
right. And then line 7, it was not as a whole. I didn't see the whole interview. And when I listened to the interview for a while, for a while in court, but I didn't want to think about it all. But you never in the interview told Mr. Dr. Hines we didn't understand, and Ms. Mulligan we made a statement saying that's not true. Mr. Graves then addressed her about making comments.
Well, now he's criticising Ms. Mulligan, who's made a comment that the appellant has just repeated as part of his evidence. And he says, now you're making comments, and he says the word, and he says the exact words that you just said. So you can hardly take complaint at that, can you? What is it?
My Lord,
in
the
relation
issue
to the
was
judge's conduct that's objectionable?
my concern for the client he had indicated that the statement of the judge that he didn't want to hear from Ms. Mulligan again, and that she was to sit down.
Where are we? On page 49 still? Well, in terms of not hearing from Ms. Mulligan, this is cross-examination of the appellant, isn't it? So Ms. Mulligan should not be speaking. It should be a dialogue between Ms. Smith and the appellant.
My Lord, what she is making is an objection at line 3 on page 50.
At line which?
Line 3 says, please may I object to the question. And Mr. Justice Graves then said, sit down, let's move on, next question.
Well, yes, I mean, what happened was, at line 9 on page 49, prosecuting counsel says, you never told Dr. Hines in the interview that you don't understand. Ms. Mulligan then wholly improperly says that's not true, whereupon Mr. Vlcek says that's not true. The judge says, you can't do this. Effectively, he says, you've been complaining about prosecution making comments, and here you are doing exactly the same yourself. At line 22, Ms. Mulligan says, I do apologize. I should have simply said I object. And she was right about that. And then at 24, Ms. Mulligan says, my friend has an obligation to put back what was in the interview correctly and not incorrectly. There seems to be a repetition of her objection. Mr. Justice Greaves said, I don't want to hear you again until your time has come. In other words, the witness is being cross-examined, don't interrupt. Ms. Mulligan says, may I object to the question? To which Mr. Justice Greaves says, sit down, let's move on the next question. Because by now the question had been asked and she'd provided the answer. So very sensible to move on. She shouldn't have done it. But the judge says, no, let's stop this, let's move on. What's wrong with that?
My Lord, the issue was the manner in which the judge did that, shouting at defense counsel and telling her to sit down. This is in front of the jury, my Lord.
Well, so what?
Ms. Mulligan should, as an experienced counsel, which she is, should not have been answering questions that enabled Mr. Vlcek to repeat her answer as happened on the previous page.
If you're saying that because when counsel behaves improperly, the judge says sit down, that gives a real appearance of bias, we're going to have an awful lot of defective trials.
My Lord, it wasn't the issue of Ms. Mulligan being told to sit down. It was the manner in which the message was
Okay, being told to sit down rather sharply, as Mr. Justice Greaves occasionally did.
So that's the one instance. Are there any more?
My Lord, that's the one that I could find with this witness, with the
Well,
evidence.
that one we have. If there are any more, you need to take us to them.
Oh, yes. I think we interpreted perfectly reasonably as asking for a request, a break. We've had rather a long session. We'll break for, is 10 minutes a satisfactory time?
10 minutes in this contract rule? Yeah.
Thank you for reminding me. We'll break. Right.
Court rise. Everything's muted. The court's watched. But we don't do lunch. Sorry. This contractor. Right, we're reconvening with the president using the new device that they improved the audio. I'm just going to invite the president to say something to ensure that Justice Foster.
Mr. Quayle, I'm just looking and I don't see Mr. Vlcek in corrections.
Ah,
Nor the interpreter.
Ms. Contractor, are you with us? Say 10 minutes.
Hello? Yes. I do apologize.
Contractor, can you hear me?
Yes, I can hear you.
Can you hear me? Ms. Contractor?
Yes, I can hear you. Yes, yes.
Oh,
Yes, sorry, I did say, I did. Sorry, I do apologize.
And can you hear me?
Yes, I can hear you.
great.
Now all we need is Mr. Vlcek.
Justice Foster, you can hear Justice Clark fine, can you?
It is actually really echoing at the moment.
Yeah, I think it's on my phone. Yeah, I usually keep my device muted. Ms. Contractor, is your telephone still live with the prison authority?
Yes, I'm still connected to them. We are still on the loudspeaker. Yes. Sorry, you were saying?
I'm sorry, you were saying something, Ms. Contractor?
No. I thought you were talking to me.
Okay. Okay.
Yes, Mr. Vlcek, Mr. Vlcek. He's in the room with Mr. Vlcek. This is Court of Appeal for him.
No.
Mr. Vlcek, can you hear us? Thank you.
Right.
I do
Well,
apologize for my for being delayed.
well, yes, and it seems to be Mr. Vlcek who was delayed, but let's get on. Yes, Miss Cassidy.
I beg, my lord.
So we're still on ground 3, are we, Miss Cassidy? Or have you finished that? think we got as far as you'd identified the one instance where you said that Justice Graves had said, sit down, let's move next question, which is page 50, line 4.
Yes.
The question you were asked by the bench was whether there were any more instances that you could point us to, and I don't think you had, in fact, been able to take us to any other instances.
Not on the transcripts. I have
Not
my
in.
Well, that I think brings us to 44, where you say the Crown Counsel, during the cross-examination, the appellant made unfounded suggestions intended to diminish the good character of the appellant. Now, what's that a reference to?
Yes, my lord, that was in reference to the Crown Counsel putting into the appellant that he was a master manipulator.
Well, can you show us where that is?
Yes, my lord.
Are you referring to the question that was put to Mr. Vlcek suggesting that he was a drug mule?
That one as well, my lord. I just had it, I'm sorry. My lord, it's reference to, it's at page 6.
Page 6?
Yes, my lord. At line 21. And that was in reference to him watching the interview.
Line 21 is Mr. Vlcek answering a question.
Right.
Yes?
So, yes. So directly below that at line 24, it was put to him, is that part of your master manipulation?
I'm so sorry, where is this?
I'm looking at the transcript.
Oh, I see, yes. The transcript of his cross-examination. Yes.
Yes.
Day 2, yes, I follow.
So what page are we on?
I have it as page 6 of the
Page-
cross-examination of Mr. Vlcek.
Page which?
6.
Page 6.
The page 6 I have, this is still evidence in chief.
No, we have to go to the next.
Oh, you're looking at the second day?
He's looking at the second day.
Yes, my lord, I apologize.
Another.
Thank you. I have. So, page 6,
Yes.
line
21. No, 20.
And that's where it's put to him, is that part of your master?
Sorry, I don't have the line. Yeah,
Line 24, my lord.
line 24. Is that part of your master manipulation?
Yes.
Well, that's a suggestion. He was manipulating the system by making various excuses, isn't it? Which is what the Crown case was. And what's wrong with that?
My lord, we say that it is impugning upon his character.
Sorry, you say that the question, is that part of your master manipulation, is improper?
Yes, my lord.
But that's the case, as my lord has just pointed out. And the somewhat surprising answer, and still I like you.
Yes. And the case that was being booked by the prosecution is that you told one story to the police, which was a tissue of lies. You then changed it in what you have just said to the jury, and that's a tissue of lies too. And you making various excuses about having difficulty to breathe at interview, and it's all part of part and parcel of a manipulation of the system in such a way as is designed to secure your acquittal in circumstances where you are in fact guilty.
It's not unknown for prosecuting counsel to suggest that an appellant is not telling the truth.
And that's not what we're taking issue with, my lord. He accepted that he had given two versions of events. And he had been called a liar, of which he accepted.
And he
had-
accepted that he'd lied.
Yes.
Yes. So
he had manipulated the system.
I don't yet understand your complaint. I mean, this is not the first time that prosecuting counsel has said that Mr. Vlcek is a master manipulator.
Well, anyway, that's the unfounded suggestion you're referring to in paragraph 44.
Right.
Then you say Crown Counsel did not establish in evidence whether such bad character allegations that were against put to the appellant. For example, it was put to the appellant as he on prior occasions committed similar offences. Now, where's that?
My lord, that is spoken to at page 13.
30, 30.
13, my lord.
13.
And that's at line 20, where again it's put to him that when things don't go as planned.
Sorry, line 20?
Yes, my lord. Where things don't go as planned, you act naive, dumb, and as if you don't understand. And it's again put to him that that is part of his manipulation.
That's what the Crown was saying he was doing. Acting naive, dumb, and as if he didn't understand when he perfectly well did. It could be said the Crown was bound to put that. Not that it was wrong to do so. But you said that this was an example of where it was put to the appellant that he's on prior occasions committed similar offences. That doesn't seem to be...
That's not what we infer from this.
Crave your indulgence, my lord, I'm just looking for the paragraph. Unfortunately, my references are all on the recordings, the transcription.
Well, that was unfortunate because
I do apologize, my lord. I can certainly make sure I have that available.
So
after. I
you're
do
moving on to
apologize. I can.
46.
My
So
lord, if
are
I,
you saying that the case of Boucher and the Queen is authority for the notion that the judge is biased if he doesn't sufficiently rein in prosecuting counsel?
yes, my lord.
Right.
There was also the suggestion of the drug countries which had not been addressed, which resulted in an imbalance in the information provided to the jury.
Well, the basis upon which it was put to him, Mr. Vlcek, that he had frequented drug countries. It was suggested by the police in the police interview that Mr. Vlcek was in fact a quote, drug mule. At that point, he hadn't come up with the evidence that he gave at trial that he had indeed traveled to South Africa at somebody else's expense for the purpose of returning to London with gold and diamonds. But that was his case, was it not? That he did smuggle into London gold and diamonds at the behest of these men he'd met in a pub.
Yes, my lord.
So he'd also explained the circumstances of his travel to South Africa. The ticket on which he traveled to Bermuda had been purchased when he was in South Africa. He lied about that to customs, as he said he had purchased it the previous day. It's hardly surprising that these suggestions might be put to him. So what does Boucher say?
Yes, please, my lord. So this is a case from the Canada, my lord. This is a case that's not particularly on bar in terms of it's a murder criminal appeal, but this is an appeal on an alleged misdirection on the doctrine of reasonable doubt and circumstantial evidence, and also the allegation of inflammatory language used by Crown Counsel to the jury.
Right.
And which is the passage we should look at?
My lord, I'm looking at page 17
Thank you.
and starting at paragraph 3.
Crown Counsel exceeded his duty.
Yes, thank you, my lord. Crown Crown Counsel exceeded his duty when he expressed in his address by inflammatory and vindictive language of his personal opinion that the accused was guilty and left the jury with the impression that the investigation made before the trial by Crown officers was such that it had brought them to the conclusion that the accused was guilty. It was improper for counsel for the Crown or the defense to express his own opinion as to the guilt or innocence of the accused. The right of the accused to have his guilt or innocence decided upon the sworn evidence alone, uninfluenced by statements of fact by the Crown prosecutor, is one of the most deeply rooted and jealously guarded principles of our law.
Well, that's not this case, and I can see that Crown Counsel ought not to say. I think you should know that I think you're guilty, and I've consulted a lot of people in our department, and they think the same. That would be improper. But to say, I put it to you that you are guilty is what happens in case after case. Counsel's proper function. Not his personal opinion, it's the case that he's putting on the evidence presented to the jury. Not sure we get any assistance from this.
Lord, moving on to paragraph 47.
Right. There's nothing else from Vlcek that you want to take us to.
Specifically
But even worse, what you say, well, what you say in 46, the trial judge, having not addressed the improper conduct and questions by the Crown Counsel in cross-examination of the applicant, did result in an apparent bias must be against Mr. Vlcek. I mean, the fact that the trial judge doesn't, in summing up, deal with the particular point which it said that he should have dealt with, that's got nothing to do with apparent bias.
So, my lord, the issue, we do come to the issue of not giving a good character direction.
That's something completely different.
We're talking about your complaint of apparent bias, and are puzzled why you should think that the trial judge should have apparent bias because of his apparent control of counsel. The one doesn't lead to the other.
So, my lord, the optics before the jury.
Sorry?
It's the optics before the jury. The jury is seeing the judge shouting and telling defense counsel to sit down. The jury is observing prosecutors making comments, being heard on recording. I could hear on the recordings laughter.
Things make the judge guilty of apparent bias.
So what it does is it creates the impression, we say, for the jury, where the prosecution is allowed to mock and make a joke of a defendant.
But when Crown taken us to those, yes.
Okay, well, let's get on to 47.
Thank you, my lord. My lord, this is the concern of the Crown and the judge making a mockery of the use of the interpreter, which we say is unfair and improper.
Now, where did that happen?
Just go back to transcripts. My lord, this did happen in cross-examination.
Mm-hmm.
It was put to Mr. Vlcek where he had said, I don't understand. It was
Where are we at?
just getting it now. My lords, I am at page 11.
Page 11. 11 of which?
I believe it's the second day, it's cross-examination.
Second day.
Right. Okay.
And it's at line 17. So this is in relation to cross-examination with regards to the communication with the customs officer, Susie Williams-Stubble. And Mr. Vlcek indicated, I don't know who she is. My Susan is over there. One can assume he means Ms. Mulligan. And then at line 17, the prosecution response was, okay, and you're acting like you need an interpreter now for the purpose of these proceedings. It's a farce, it's a joke, it's a lie. And then Ms. Mulligan addressed the learned judge and said, do you have an objection to that line of question? I'm in the court's hands. And the response was, it's a very, very serious matter. I do want to know everything that is being said in this court. I want to understand everything. And the prosecution's response was, you understand everything in this court without the aid of the interpreter. And his response was not everything.
Well, that's what's being put to him. That it's all part of manipulating the system, that in fact it spoke English. And then put that you are a drug mule. That's the prosecution case.
We respectfully submit that having had the assessment and an interpreter is provided and available for the court, it is improper for Crown Counsel to then be suggesting to the appellant that it's a farce, it's a lie, and in essence that he's manipulating the system or the jury, exercising the right to interpret.
Put that question, and his answer is no. And he's answered it by saying it's a serious matter, and he thought it was important to understand. I do want to know everything that has been said in this court. I want to understand everything. That's his right to say that. And it was his right to say that he needed an interpreter. But you said in paragraph 47, the conduct of the Crown and of the judge.
And the conduct of the judge that we speak of is,
Sorry?
the conduct that we speak of is the ruling at the beginning of the case, where the interpreter is asking for the judge to slow down so that she can interpret what's being provided for in the ruling.
And the judge said, you don't need to interpret, it's the ruling.
Yes.
Yeah, I mean, we've been to that one before.
Right. That, I mean, the judge saying he wasn't going to he wasn't going to slow down because the ruling didn't have to be immediately translated was not a mockery of using an interpreter. He was simply saying, I'm delivering my ruling. Don't stop me doing so. It can always be translated later. Right. So where do we go to next? Ground 4.
So, my lord, just continuing along that vein, it's our respectful position that the trial judge ought to have instructed the jury that the use of an interpreter for a foreign-speaking national is a fundamental right that should be ensured to ensure the appellant had a full understanding of the legal proceedings without a language barrier.
Right.
Did the judge in fact say anything in his summation about the use of an interpreter? I thought that he had done.
Yes, I thought he had.
Page 41.
Which page?
Page 41 of the, letter of you.
Right.
And my lord, our position is that indication should have been given immediately after the negative inference was given to the jury.
Well, your complaint in the second sentence in paragraph 48 is the trial judge ought to have instructed the jury that the use of an interpreter for a foreign speaking national is a fundamental right which should be exercised to ensure that the defendant has full understanding. Page 41, to which Ms. Clark has kindly drawn our attention, that it is the judge says, it is the practice and the law in many jurisdictions of the world, including this one, that when a person faces trial in the jurisdiction of which his primary language is not spoken, then he should be afforded an interpreter to assist him, and that's the reason why the defendant has an interpreter.
I know you may have, from some things that the prosecution might have asked him, felt that you were being encouraged to think that this was some maybe scam on his part, to pretend that he can't understand English or something like that. You must put that out of your minds. You must put that out of your considerations. You must not draw any adverse inference against the defendant because he used an interpreter. How could the judge have been clearer?
I'm guided, my lord.
Right.
So you agree that that's an answer to that point?
Yes, my lord.
Right. Thank you. Right. I think we've got to ground 4.
Yes, my lord. And this is in relation to a good character
Yes.
direction. My lord, I am mindful that my friend Miss Mulligan ought to have requested the court to give a good character direction. But I am also mindful that the trial judge did also fail.
Well, you're quite right. A, the judge should have given a good character direction. But B, as you said, the judge in the usual way asked if there was anything that he ought to have added, and neither Miss Mulligan nor the prosecution referred to this.
Yes, my lord, but that still doesn't relieve the obligation of the judge to still give that good character direction, having had no bad character evidence adduced.
Right.
Right.
Yeah, well, that may be a good point.
And my lord, it's our position that the trial judge, having heard through the evidence the appellant called a liar and a manipulator, and in essence using a translator to persuade the jury to be sympathetic, having failed to give that good character direction, did leave with the jury a negative inference relating to the appellant's good character.
Well, wait a moment. Left with the jury a negative inference. I can see that if the judge doesn't give the good character direction, he doesn't draw attention to the fact that the defendant is of good character and tell the jury that they should bear that in mind in assessing the case against him. But the fact that a judge doesn't give a good character direction is not a suggestion that the defendant is of bad character. It's just a failure to give the direction that he's of good character.
And let me ask the question, Ms. Cassidy. If a defendant has admitted that he lied in his police interview, does that not suggest that he is of less than perfect character?
My lord, I would say that it would speak to the fact that he had been dishonest on one occasion, but it
Well,
certainly
he
didn't.
lied in respect to something that was really quite material,
Yes, my
and
lord.
he was cross-examined on it by prosecuting counsel, and he conceded that he had lied in his police interview.
Yes, my lord.
It wasn't just a lie on a matter that of small importance. It was a lie to the police
Mhm.
on a very important matter, namely where he had acquired the suitcases.
Yes, my lord.
But does that not have relevance on the issue of what should have been said by way of a good character direction?
And the judge did address the jury on the lies, but he did not address the jury on good character. So it was left.
But that was my point. That and no doubt Mr. Clark can deal with it. Whether or not someone who has admitted in cross-examination that he lied on a highly material matter is entitled to the full benefit of a good character reference.
Because on one view, the judge should have said, members of the jury, of course, before the events with which this case is concerned, the defendant was of good character, and you must take that into account, but you are entitled also to bear in mind that he attempted to pervert the course of justice by the lies that he told first time round.
Yes, my lord, and that would have been proper.
Well, that would have been...
It would have been proper, but he did address the evidence in terms of the police interview and then the evidence given on the stand.
Right.
And the jury's responsibility to carefully consider those. But having it left on that, there was no address on the previous good character.
Yes, I see. Right. Okay. Round 5. Where did the judge during the trial mock the appellant's defense and bolster the case for the crime?
My lord, my instructions are that is what the conduct was of the judge throughout the trial.
What
From
was
Mr.
what
Vlcek.
throughout the trial?
Throughout the trial in terms of other witnesses.
I still miss the word that described the judge's conduct.
My lord, I didn't see that specifically in what was provided on the recordings. That was the instruction from Mr. Vlcek, that throughout the evidence, he felt that any questions that Ms. Mulligan had put in cross-examination or an effort to properly advance his case were met with mockery, and that the Crown's case was put in a positive
Well, I'm
aspect.
afraid, for my part, I need to have some detail of what these complaints are.
Well, what you've told us is those were your instructions, but you hadn't perceived that on the recording.
Can I come in there, Mr. President? Ms. Casti, I would be very grateful if you could
So
take
on
us-
that basis, listening to the recording, Justice Gloucester has a question.
Sorry, I interrupted you. I had put my hand up.
Well, just a minute. But I mean, on that basis, your instructions were that the judge had mocked the appellant's defense. But if you listen to the recording, there's nothing that indicates that that was so.
Not in the recordings I had available, my lord, no.
Right.
Sorry?
Okay.
Not
in the recordings I have available.
Right.
Justice Gloucester, did you have a question?
Have you, can you take us to anywhere in the transcript which reflects the notion of the judge mocking the defendant, or is an example of it?
I think Ms. Cassidy's just said that she can't.
I don't mean the recording, I mean the written transcript. I mean, there's obviously a difference between where the judge's body language, it is suggested, shows a mocking demeanor, and obviously As you just said, you can't show us an example of that. But what about in the written transcript? Are you able to show us an example there?
My lady, if I could perhaps address that after the break. I can certainly point, because I'd be able to point it specifically to in the
I'm
transcript.
sorry, I've got to speak. I can't hear it.
It says you need to address that after the break.
If I may.
Sure.
Right. Well, we'll take a break in a moment, but let's just see where we've got to. That's really your last point, isn't it? Because what effectively you say in paragraphs 57 to 59 is that the upshot of all that was that he wasn't heard by a fair and independent judge, and he didn't have a fair trial, and there's been a miscarriage of justice, and the conviction is therefore unsafe.
Yes.
Well, I think that might be a convenient moment to adjourn, and if you're able to find any indications on the transcript of what you describe at paragraph 55 of your skeleton, that would be helpful.
I'm most grateful, my lord.
We'll adjourn until 2 o'clock.
Yes,
Hello, hi. Custody, maybe you can give me a call now. I'm ready. Slyšíme se?
Jo, slyšíme.
Super.
Yes, thank you, my lords and my lady. I am most grateful for the opportunity to review that over the break. What I can indicate is that on the typed transcript of the proceedings, I am unable to see any annotations that indicates whether there was the actions of laughing or coughing or anything to that effect. It's strictly words translated. My lord, I did wish to address the court in terms of certain statements that were made by the learned judge in his summation, with specific to reference to the mixed statements direction. Mixed statements direction.
Mixed or missed?
Mixed, M-I-X, yes. Yes.
Can you show us the passage in the motion for those notes?
Yes, my lord.
No. I do apologize. I am having a difficulty to hear.
Yeah,
okay.
Mr. President, you're muted.
Justice Costa, did you have a question?
You are muted, or you
I'm
were.
not now. I find.
No, I know, but when I tried to speak, that was why.
Right. Thank you.
So on the summation, Ms. Kathy, and you can take us to the part.
Yes, my lord. So the page for mixed, the direction on mixed statement is at page 26.
Is that of the record of appeal or?
The record of appeal, my lord.
Yes, thank you.
Starting at line 10.
My summation starts at 28. Oh, no. Page 26.
Oh, I'm so sorry, my lord. I am looking at the record of appeal, page 53.
Right.
I apologize.
Yes.
So at line 12.
Yes.
It says mixed statements. In this case, in the interview the defendant gave, that is what is referred to in the law as a mixed statement or a self-serving statement. It is also referred to because sometimes in it, the defendant makes certain admissions or even incriminating parts. And on the other hand, he sometimes makes denials or excuses or uses some explanations likewise. So looking at his interview, When you are considering that, you must consider the whole of that statement or that interview in discerning where the truth lies. So for example, so he goes on to speak of South Africa. And continuing down onto the next page at line 8. Or you might look at some other excuses or explanations where he might have said, I'm going to keep quiet now. I'm not telling anything. So that is a mixed statement. My Lord, going down to page 58 of that same record. At line 21, this is where special directions are being given. It might have been suggested, or you might have got the impression that it might be suggested that the defendant was seen to be some international drug smuggler. All these trips he making to, all to South Africa and Tanzania and back to England, saying he brought back diamonds and gold that he never saw. But in the case of South Africa to England, he did touch. So my Lord, the concern of the appellant is the suggestion, and putting it directly to the jury, that there was a suggestion that he was an international drug smuggler. When
the point the judge is making was that that had been raised, but the crux of this comes at line 13, where the judge says, I must strongly caution you, strongly direct you not to draw any such inference, not to jump to any such conclusion. And he carries on, put it out of your minds. We're only concerned with whether the defendant brought these drugs to Bermuda knowingly or suspecting or having reason to suspect. So do you make any criticism of what the judge says there? That is to say from line 13 to 22 on page 59?
Yes, my Lord. Specifically that the judge ought to have directed the jury that there was no evidence before the court to support the suggestion that he was a drug smuggler.
He doesn't say there was evidence. He's directing the jury not to draw any inferences, not to jump to any conclusions, because it is the case that it had been suggested that by reason of the traveling that the appellant did, that adverse inferences might be drawn from that. Judge says, put it out of your mind. I'm not sure what else he could have done or should have done.
My Lord, the concern raised is that it ought to have been very directly put to the jury that that was information that was not properly before them. And in essence, he's
highlighting. I'm sorry. The judge is saying, don't draw inferences, don't jump to conclusions. It's not a question of any dispute about underlying facts. So they've had this evidence. He traveled to South Africa and Tanzania, back to England, brought back diamonds and gold, so on and so forth. Those are the factual matters, and the judge says, don't draw inferences, don't jump to conclusions.
Yes, my Lord, the appellant's position is that the direction to the jury ought to have been more clear.
Well, how could it possibly have been clearer?
But that's information that they are not to consider.
But that's what he said.
I'm guided, my Lord.
Right. Thank you. Are there any other matters that arise on the appeal against conviction?
No, my Lord.
Thank you. Thank you very much.
I'm grateful.
please feel free to address us on anything you like, but what we'd really like to hear about is any observations that you have to make about the failure to give a good character direction to the...
Yes, on that point, my lord, I do wish to start my submission by confirming that there was no evidence before the trial judge of this appellant's good character. It was not raised at all.
Oh.
Not in cross-examination of any prosecution witness. And not in the evidence in chief of the appellant.
Madam Director, you
Oh, right.
I do apologize.
Did she hear
May
me,
I
or do you
just
want me to
ask
say
a
that
couple?
again?
Yes,
No,
that's
I
much
think you better
better.
say that again.
I'm grateful. I'm sorry to the interpreter. My submission was that there is no evidence before the trial court of the good character of the appellant.
And you're saying in those circumstances
It was not properly raised.
that there's still no obligation on the trial judge to give the good character
So there is
direction?
a Privy Council case, my lord, but the answer I would say in short is no. Privy Council at tab 19.
TLAC?
TLAC, yes.
Yes.
So it is a Privy Council case from Trinidad and Tobago. It is a death penalty murder case. The relevance to this case starts at paragraph 18, which is on page 6 of that authority. Paragraph 18, at the end of his examination in chief, TLOC stated at their record, page 196, I have never been arrested for any matter or charged or any matter except for this matter. The police have never arrested me for any matter. That was not in fact true, as it had been established since that he was arrested on a previous occasion and charged with possession of drugs. He pleaded guilty to the offense and was fined the sum of $400. He was not, however, cross-examined about this at the murder trial. So that's in relation to the defendant, TLOC. If we go to paragraph 24, which is just over the page on page 8. At 24, during the course of his examination in chief, John said, record page 209, when I was taken from CID, I was handcuffed. Both hands were handcuffed. Both handcuffs remained on. When I reached home, I was embarrassed. It was the first time I was under arrest. At the time of his trial, John had no convictions recorded against him, and his evidence that he had never been arrested was not controverted. So if we go over to paragraph 31, my lords and my lady, which is at page 11 of the authority.
Yes.
The court says, their lordships therefore turn to the matter which formed the substance of most of the arguments placed before them, the question of good character directions. The judge did not give a good character direction in respect of either appellant. In the Court of Appeal, counsel then appearing for TLOC withdrew the ground of appeal relating to this issue on the ground that the appellant's character had not been sufficiently raised in the evidence for it to become an issue in the case. For the same reason, the Court of Appeal, at their record page 403 to 4, held that it had not been sufficiently raised in relation to John. Both appellants made the case before the board. The judge should have given a good character direction. The evidence set out in paragraphs 18 and 24, which I've just read, of his judgment, having been given in the course of the trial. In the alternative, it is submitted on behalf of each that the omission to bring out the appellant's character and to ensure that a proper direction was given by the judge was incompetence on the part of counsel of such a degree that the verdict should not stand. The principles to be applied regarding good character directions have been much more clearly settled by a number of decisions in recent years. And what might have been properly regarded at one time as a question of discretion for the trial judge has crystallized into an obligation as a matter of law. There's already quite a substantial body of case law on the various aspects of the application of the principles, not all of which is relevant to the present appeals. Their lordships consider that the principles which were material to the issues now before them can conveniently be encapsulated in the following series of propositions. 1, when a defendant is of good character, i.e. he has no convictions of any relevance or significance, he is entitled to the benefit of a good character direction from the judge when summing up, tailored to fit the circumstances of the case. And I pause at this point to say, my Lord President, during my learned friend's submissions, pointed out quite rightly that this particular appellate had already been accepted as a liar. And so it wouldn't have been a full 2-limb character direction in any event. It would have had to have been tailored.
Sorry, you're referring to the questions that I put to Ms. Cassidy?
I believe so, when we indicated that there was a Lucas direction was given because the lies had been proven and he accepted them.
And he accepted that.
So he would not have been given a full character direction. He would have only gotten a modified character direction in any event. And I would also pause to say it would have also been modified because of the acceptance of him moving the diamonds and the gold would not have been lawful in those jurisdictions that he himself testified to. So he would not have been entitled to the full good character direction.
So you say 2 bases on which that would arise. 1, the lie, and
to the admission of the gem smuggling.
The rule of the gold and diamonds.
Yes.
When that was unlawful.
Why was that unlawful?
Well, it wasn't declared when he
Oh,
came
I
in.
see, yes. The import was unlawful.
Import, yes. Unlawful importation, I believe it's under the Customs Act. Grateful. If I can pick up at the second proposition. The direction should be given as a matter of course, not of discretion. It will have some value and will therefore be capable of having some effect in every case in which it is appropriate for such a direction to be given. If it is omitted in such a case, it will rarely be possible for an appellate court to say that the giving of a good character direction could not have affected the outcome of the trial. And I pause to say the Privy Council has indicated it would be rare. It doesn't say it would never happen. The third proposition, the standard direction should contain 2 limbs, the credibility direction, that a person of good character is more likely to be truthful than one of bad character, which we can say would be problematic, bearing in mind the court had to give a Lucas direction in this case. And 2, the propensity direction, that he is less likely to commit a crime, especially one of the same nature with which he is charged. And we just read, my lords, the section where the court warned and directed the jury not to consider any propensity evidence. The fourth proposition is where credibility is an issue, a good character direction is always relevant. And we say the fifth and the most important is the defendant's good character must be distinctly raised by direct evidence from him or given on his behalf or by eliciting it in cross-examination of prosecution witnesses. That did not happen in this case, my lords. And it goes on to say, it is a necessary part of counsel's duty to his client to ensure that a good character direction is obtained where the defendant is entitled to it and likely to benefit from it. The duty of raising the issue is to be discharged by the defense, not by the judge. And if it is not raised by the defense, the judge is under no duty to raise it himself.
So that covers the facts of this case.
I believe it does. And just to actually drive the point home, if my lords turn over to paragraph, actually, if we look first at 34, where I just sort of finished, without having to go through all of it, the Privy Council considered that in Tilot's case, that it wasn't properly raised, even though Tilot gave evidence that he'd never been arrested, and that turned out to be false. They felt it was not properly raised. So if you look, it's sort of in the middle of paragraph 34, about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 lines from the bottom. The matter is put beyond doubt, however, by the fact that giving of this evidence was not in their lordship's view sufficient to raise the issue distinctly. So the Privy Council is saying even having a defendant say in the box, I'd never been arrested, is not enough.
Takže tam bylo vlastně to, že i když nebyl nikdy začen, to neznamená, že to je
And that's
dostatečný.
confirmed over on
A to je
paragraph
potvrzeno.
35.
Sorry.
When they
I
say
do
the
apologize.
case presented on behalf of John raises rather more difficult issues, because remember, he's the one who did not lie. He had no previous convictions. He said in evidence in the context of his embarrassment at being brought home in handcuffs, that it was the first time he had been under arrest. That appears to have been correct, for it was not in dispute that he had no convictions. For the reasons which they have given in respect of TLOC's appeal, however, their lordships consider that this was insufficient to raise the issue and that the judge was not at fault in omitting a good character
Mr.
direction.
President, the interpreter is trying to put her hand up and no one's hearing her.
Do apologize. I've been raising my hand for some time. I'm trying to ask the council if she can please slow down because I am. It's very, very fast for me. I do apologize for raising it up, but it's very fast for me.
Yep.
Thank you.
Your point is accepted, Madam Interpreter.
And I was making such an effort to try to speak slower.
No,
I know that
you seem to be speaking very fast now.
Yes.
Now make an effort to speak even more slowly.
I think council should go back.
No, my lords, it's
I appreciate that.
I think council should go back to the beginning of the citation because the hand went up from Paulina very, very early on.
Yes.
So back to the beginning of this case.
Yes, I fear you've got to go back to, well, the beginning of the your citation of this case.
I'm grateful. I will try to speak slower. Is my lady with us on tab 19 at TLOC? I believe so, yes. Okay, so I did start at paragraph 18, which is on page 6. And I read, at the end of his examination in chief, TLOC stated, I have never been arrested for any matter or charged for any matter except for this matter. The police have never arrested me for any matter. This was not in fact true, as it has been established since that he was arrested on a previous occasion and charged with possession of drugs. He pleaded guilty to the offense and was fined the sum of $400. He was not, however, cross-examined about this at the murder trial. I then moved to paragraph 24 in respect of the second appellant in the case. During the course of his examination in chief, John said, when I was taken from CID, I was handcuffed. Both hands were handcuffed. Both handcuffs remained on. When I reached home, I was embarrassed. It was the first time I was under arrest. At the time of his trial, John had no convictions recorded against him, and his evidence that he had never been arrested was not controverted. And I paused at that point, my lords and my lady, to remind the court that in this case at bar, we have no positive evidence from the appellant, not through cross-examination of any witness, and not through his own evidence in chief of his good character. And then I moved, my lords, to paragraph 31, I think I started with, on page 11. Their lordships therefore turn to the matter which formed the substance of the most of the arguments placed before them, the question of good character directions. The judge did not give a good character direction in respect of either appellant. In the Court of Appeal, counsel then appearing for TLOC withdrew the ground of appeal relating to this issue, on the ground that the appellant's character had not been sufficiently raised in the evidence for it to become an issue in the case. For the same reason, the Court of Appeal held that it had not been sufficiently raised in relation to John. Both appellants made the case before the board that the judge should have given a good character direction. The evidence set out in paragraphs 18 and 24 of this judgment having been given in the course of the trial. In the alternative, it is submitted on behalf of each that the omission to bring out the appellant's character and to ensure that a proper direction was given by the judge was incompetence on the part of counsel to such a degree that the verdicts should not stand. The principles to be applied regarding good character directions have been much more clearly settled by a number of decisions in recent years. And what might have been properly regarded at one time as a question of discretion for the trial judge has crystallized into an obligation as a matter of law. There is already quite a substantial body of case law on the various aspects of the application of the principles, not all of which is relevant to the present appeals. Their lordships consider that the principles which are material to the issues now before them can conveniently be encapsulated in the following series of propositions, of which there are 5. The first is when a defendant is of good character, i.e., has no convictions of any relevance or significance, he is entitled to the benefit of a good character direction from the judge when summing up to the jury, tailored to fit the circumstances of the case. And at that point, I pause to remind the court that we have an appellant who had admitted that he had lied to the police, and an appellant who had admitted to committing offenses under the customs and excise legislation of importing without declaring the gold and diamonds that he thought he had with him. And so he would not have been entitled to a full good character direction. The second proposition, that the direction should be given as a matter of course, not of discretion. It will have some value and will therefore be capable of having some effect in every case in which it is appropriate for such a direction to be given. If it is admitted in such a case, it will rarely be possible for an appellate court to say the giving of a good character direction could not have affected the outcome of the trial. And I paused at that point to highlight that the Privy Council did not say that it would be impossible for the appellate court to say that if this appellate had gotten a good character direction, it could not have affected the outcome of the trial. The third standard direct is that the standard direction should contain 2 limbs: the credibility direction, that a person of good character is more likely to be truthful than one of bad character. And I pause to say that as per my previous submission, that would have been difficult in the circumstances of this case, when the court was required to give a Lucas direction about accepted lies. And the propensity direction, that he is less likely to commit a crime, especially one of the nature with which he is charged. And I paused at that point to remind the court that we had just read a section in the summation where the court gave a direction about propensity evidence and how that could be used and how the jury should in fact disregard it in this case. The fourth proposition, where credibility is an issue, a good character direction is always relevant. The fifth proposition, which I said was the most important and most relevant to this case, the defendant's good character must be distinctly raised by direct evidence from him or given on his behalf or by eliciting it in cross-examination of prosecution witnesses. That did not happen in this case. It is a necessary part of counsel's duty to his client to ensure that a good character direction is obtained where the defendant is entitled to it and likely to benefit from it. The duty of raising the issue is to be discharged by the defense, not by the judge. And if it is not raised by the defense, the judge is under no duty to raise it himself. I think that was as far as I got. So in paragraph 34, 10 lines from the bottom, the board made comment that they accordingly consider that the judge was not under a duty to raise the issue and there was no misdirection. I think I read just prior to that. The matter is put beyond doubt, however, by the fact that the giving of this evidence was not in their lordship's view sufficient to raise the issue distinctly. And if my lords remember, that is in relation to the defendant Tlock, who specifically said he had not ever been arrested. And then I went over to paragraph 35. The case presented on behalf of John raises rather more difficult issues. He said in evidence, in the context of his embarrassment at being brought home in handcuffs, that it was the first time that he'd been under arrest. That appears to have been correct, for it was not in dispute that he had no convictions. For the reasons which they have given in respect of Tlock's appeal, however, their lordships consider that this was insufficient to raise the issue and that the judge was not at fault in omitting a good character direction.
Just pausing there, it does not arise on the facts of this case, but I'm a little puzzled as to why their lordships thought that saying that this was the first time that he'd been under arrest was insufficient to raise the issue of good character, when, as paragraph 33(1) indicates, a defendant is of good character, i.e. has no convictions of any relevance or significance. I mean, if I say I've never been arrested for anything, doesn't that necessarily mean, and I haven't been charged, let alone convicted of anything either?
I would have thought so, my lord, but there's a reason why I still stand here, and there are people in the Privy Council who know better than I do.
Possibly.
Well, they do make it clear or perhaps what they're trying to get at, my lords, is that simply saying arrest is not enough.
Well, I know that's what they're saying, but if I say I've never been arrested, well,
if one would logically assume that means you've never been convicted.
Yes.
I suppose in theory, you could have omitted that you've been summoned.
And his lordship might well have perpetrated some enormous fraud in respect of which he was never arrested, but was in fact charged and convicted.
Yes. Yes. Well, anyway, their lordships make plain that you have to say in terms, I have never been convicted.
Yes. In any event, we have nothing. Neither I've been arrested or convicted.
No.
And we also have no affidavit from Ms. Mulligan to indicate whether or not she had any specific instructions. This is not.
She doesn't. She filed an affidavit.
Yes.
She doesn't deal with this point.
She does not. No.
Yes.
And not only is there no evidence, my lords, when, assuming it was a mere omission, which I don't accept, by Ms. Mulligan, who was very detailed usually in her handling of matters.
Yes.
She did not raise it in the discussion prior to the summation, and she did not raise it in the course of the summation when the judge asked if there was anything he had omitted. She did in fact take an opportunity at that point to say that she didn't feel that the judge had put the defense case as strongly as she felt, but made no mention at all of a character direction.
What was it? There were grounds of appeal which Ms. Mulligan had drafted.
Yes.
Did that cover the good character direction?
I don't believe it did, because remember, Ms. Mulligan's submissions were for leave and the good character as a ground of law alone. So I don't know if she specifically addressed it, but I can look quickly.
I'm just looking.
Because I know I did not specifically address it in my original submissions for that very reason.
No, page 244 in the notice of appeal of the 14th of March 2019 says the learned trial judge erred in failing to instruct the jury on the appellant's good character.
I think that was the extent of it.
And that's 244?
244. Right.
I don't think that she, I was just saying, I don't believe that she, in fact, extrapolated or went any further in her submissions that we did have before the court. And she hasn't, surprisingly, in the drafting of this ground 9, did not particularize anything to the effect of, Learned Child Judge erred in failing to instruct the jury on his good character, having been reminded, having had the evidence. Nothing further is supported in her draft ground.
No.
I will just quickly check her original submissions.
Yes, I'm looking at them too. Yes, it's at page 13 of her original submissions.
Grateful.
Despite the fact that the prosecution was not alleging that the applicants had any prior criminal convictions, the trial judge failed to give the required direction to the jury regarding the applicant's good character. This was a grave and significant error.
Oh, it's just the one paragraph.
Yes.
Which is, might I say, rather unusual for Ms. Mulligan. But I will indicate, my lords, in response that she does not say or reference any portion of the evidence where she in fact did raise it.
No.
And I say that was quite correct because she did not do so.
No.
And so, my lord, my submission would be in keeping with TLAW. 1, it was not properly raised, the issue of good character. And so therefore the judge was not required. Two, even if there was an error on counsel's behalf for not raising it, the omission was not such as to cast doubt on the safety of this appellant's conviction.
Yes.
Unless I can assist you further on that point, my lords.
No, thank you very much.
Do you wish me to address it all on the interpreter issues, my lord?
For myself, not. Do you wish to hear further arguments on anything else?
Okay, my lords.
No, unless Justice Gloucester wants to
Oh, yes, of course.
hear anything on
That's a
it.
no.
No, she doesn't. Right. Thank you.
Thank you.
Yes, Ms. Cassidy. Doesn't look as if the good character point's a good one. Right. Well, I don't want to stop you saying anything, but in the light of the clear decision of the Privy Council by which we are bound, it does not seem to me that the point is maintainable by you. If you want to persuade me to the contrary, please do.
When that point was in conjunction with all of the other issues that have been raised.
Yes, yes.
That-
Just one. My lord, that issue was, my lord, the lady, that issue was raised in conjunction with the other aspects of the issue of the appeal.
Yes. Right. Well, we have them in mind. Right. Well, that I think is all that we need to deal with in relation to sentence, to conviction. And I think we'd now like to hear from you in relation to the appeal against sentence.
Yes, please. Thank you, my lord. My lord, the appellant was found guilty after a trial before a jury. My lord, the appellant takes issue with the sentence of 30 years.
Mhm.
It's our respectful submission that the sentence is harsh and excessive in all of the circumstances. My lord, specifically taking into account the case of Yengus or Jengus from 2014.
Just have a look.
Zagalis, I'm sorry.
Oh, Zagalis. Yeah. Right.
Oh, yes, sorry, yes. Right, tab 18 of our authorities. Zegelis. Yes.
Yes, my lord. Accepting that it is a different type of drug and noting the value of that drug being 48 million. This is a case of which is a drug importation done with knowledge. It's an importation that included a firearm and also ammunition. And this gentleman received a total sentence of 25 years. My lords, I do note
I mean, one of the problems with this report, as you will anticipate, is that it covered the appeal against conviction, and whilst it's very helpful insofar as it gives facts, it finishes by saying there is no appeal against sentence in this case. Do we know whether the 25 years that covered the sentence for the possession of the weapon? It did. So,
and I believe the weapon and ammunition were dealt with consecutively as well. I'm unable to speak.
Was concurrent, I understood Ms. Clark to be saying.
I was saying it did, and they were consecutive because the statute requires it. It was a totality sentence. That's what they do.
So what was the sentence in respect of the drug portion of the?
I will have to double check it.
Right.
Well, it's all important to know which.
Yes.
I know at that time, I was counsel involved.
Yes, I've seen.
Was that it was 15 years given for the cocaine with the 10 years consecutive on the basis that.
Excuse me, we can't hear counsel because she's on mute.
But in which case, Ms. Clark, the sentencing judge.
Sorry, we cannot hear counsel.
Yes, no, I'm sorry. I said 10 years, my lady, for the
So could you
cocaine
start the
offense.
sentence again?
Sorry,
As if you're
15
on
years for the
mute.
cocaine offense with 10 years consecutive for the firearms offenses. And that it was a global sentence as opposed to a specific case that referred to certain previous cases for authority for the for what the appropriate tariff should be, because the court was concerned about giving a sentence higher than 25 years. Because the statute requires that any ammunitions offense be consecutive to the drugs offense. So that's somehow we find
The
ourselves.
sentencing judge does seem to have approached this sentencing on the basis that it was in Zagelis a sentence of 25 years for the importation of cocaine.
Yes, because as I mentioned, it was a global sentence, and the sentencing remarks, which we
So
don't
it
have.
wasn't it, you're saying it's not 15 plus 10?
Well, no, I'm saying.
Wait, you must speak more slowly.
I'm sorry. I'm saying that in Zagelis, in coming to 25, which the judge found to be the appropriate tariff for the facts of that case, had to find a way to make a portion of it consecutive because the statute requires him to do so. And the statute requires that at least 10 of those have to be attributed to the firearms offense. So having found that 25 years is the appropriate sentence, he then broke it down to say 10 years have to be for the firearms offense, and so therefore 15 is for the cocaine offense.
Well, I follow that, but in those circumstances, it can't be right, can it, to say that he received 25 years for the importation of what was a very large quantity of cocaine. And that's what the judge did say during the sentencing.
Yes. To be fair, I would have to say that in saying that, I know that that judge would have been speaking about the global sentence as opposed to just for the cocaine.
Well, I'm not sure I understand this expression, global sentence.
Oh.
I mean, I appreciate that the judge was constrained by the need to have a consecutive sentence
Yes.
for firearms offense. But he felt that overall, the position ought to be 25 years.
That's
Who
correct.
was the sentencing judge in Zagelis?
Justice Graves, the same judge.
Graves.
But I didn't wish to interrupt my friend. I would argue Zagelis isn't useful to us at all, but I'm waiting for
Sorry,
my.
more slowly.
I would argue Zagelis isn't useful to us at all, notwithstanding the judge made reference. There are other authorities that support the sentence of 30 years in respect
But
to this
it's
case.
still important for us, I think, to know whether it can properly be said that Zagelis involved a sentence of 25 years for the importation of cocaine, and that might be a simplistic way of looking at it.
My response, my lord, would be that is rather simplistic. I believe what the.
I'm sorry, could I just ask? Do we have the,
No, we got that.
sorry.
Okay, my lord, I said I would argue that yes, that would be a rather simplistic interpretation of what the sentencing judge meant in this case.
Yes.
I think he was simply referring to the importation in Zagelis as opposed to just the importation of cocaine.
But, I mean, the statement is made, I'm reading from the sentence.
Yes.
Remarks. The prosecution also relied upon the case of Zagelis,
Yes,
where that defendant imported 164 kilograms of cocaine, so an enormous amount.
yes,
And after a trial, he received 25 years of imprisonment. The Zagelis case establishes the high marking Bermuda for the importation of cocaine.
yes,
And he carries on to, so he makes no reference to firearms.
he doesn't. But Zagelis was convicted of both. Importation of, it's one firearm and multiple rounds of ammunition, plus the cocaine in Zagelis.
Hmm.
Not actually very satisfactory.
No, because I mean, I know what you say, that he had to impose a consecutive sentence of 10, and he didn't want the whole sentence to be
More than 25.
more than 25, and therefore the drug sentence was 15. But what that means is that the sentence for the drugs was 15. If there hadn't been a firearm as well, it might have been higher than 15.
That's correct.
But that's as far as one can take it.
It is, especially since this court never had a chance to adjudicate Segelis' sentence.
Yes.
So, but for the firearms offence, it could be said that the sentence for the cocaine importation might have been more than 15.
I would argue it would have definitely been more than 15.
Right.
I'm grateful.
Okay.
And I'm sorry to interrupt my friend.
Thank you. Sorry that involved us interrupting Ms. Cassidy, but I think it's helpful to know the true position.
I'm grateful, my lord.
Yes.
It's the appellant's position that if an offender brings in 14 million in cocaine coupled with guns and ammunition, that it would be improper for the learned judge to have then imposed a sentence higher with statutory aggravating circumstances. Crown Counsel in her sentence submissions did state that there were statutory aggravating factors, of which we respectfully disagree. The quantity and the manner of which the drugs were brought in are not aggravating factors, but merely the facts of the case. Aggravating features would be a previous recorded criminal history. It would be the presence of additional drugs, being more than one type of drug, the possession of weapons, large quantities of cash, ammunition, and guns, none of which were present in this case.
So what do you say is the starting point before the statutory uplift for the appropriate sentence for importation of this quantity of heroin?
My lord, I would say 12 to 15 years on the basis that on the evidence of the case.
Well, that with the statutory uplifts gives 18 to 22 and a half with the statutory uplift.
Yes, ma'am. My lord, we also submit that the court ought to have taken into consideration the personal circumstances of the appellant.
Yes, well, perhaps you can help me here because I'm aware of the debate in relation to the grant of parole in respect of prisoners serving sentences who are not Bermudian. Could you just reiterate for me what the true position is on that?
Yes, my lord. So the issue on parole is that the appellant would not have the benefit of being able to reside or, in essence, sustain himself in Bermuda, being not here.
So let's just take the sentence of 30 years. When would this appellant be eligible for early release? And
At 1/3, my lord, but there are specific conditions he must meet. For example, he does not have the right to reside at his leisure in Bermuda or the position to obtain employment.
Well, that's what I thought was
neutral position so that in practical terms, a foreign national is may strictly be eligible, but in practical terms, he would not be eligible for release at the 1/3 point, would he?
That's correct, my lord.
So at what stage does he become eligible for release, early release? Or is there any such stage?
I'm not certain that there is any such stage until he had satisfied his time, because he would not be entitled to be out on a license in the community. He would in essence not be able to secure accommodation or reasonably support himself using legal means, and would be here afoul of the Bermuda immigration rules.
Thank you. I mean, that's what I thought the position might be.
Yes, my lord.
The sentencing certificate, exactly.
Could I just ask, would he not be deported after serving a certain sentence?
Justice Master, we didn't hit the start of that.
Could I ask this question? Would, Miss Cassidy, would the defendant be eligible for release on the basis that he was deported or not? Early release on the basis he was deported?
Thank you. And that's an excellent question. It would need to be an appeal to Her Majesty the Queen to either commute his sentence to serve in his home country, if leave was granted for that. The alternative would be that he wouldn't be allowed to go until he had completed his sentence.
What, the entirety of his sentence?
Yes, my lady.
So he can't be released on license unless the governor or Her Majesty the Queen authorized his deportation to a prison or correctional authority in another country. Is that right?
Yes, my lady.
But what would happen to him there? Assume that Her Majesty or the governor on Her Majesty's behalf were to say that he could serve the last 2/3 of his sentence in Czechoslovakia. Would he be entitled to parole in Czechoslovakia? Because if he had been a Bermudan national, he would have been entitled to parole in Bermuda.
I'm afraid I'm not fluid with Czech law, my lord.
No, neither am I.
It would certainly resolve the second half of his complaint, which is the hard time due to the language barriers.
Yes.
Ms. Cassidy, Mr. Quello has just brought up on my screen.
On mine.
The sentencing certificate, which does indicate that in respect of Camp 5, which is imposition of the Controlled Drug Quantity Section 4.3 of the Seizure Drugs Act, Zagalis was in fact sentenced to 25 years.
Yes. He was sentenced to 12 years imprisonment on counts 1 to 4, which were the weapons, the firearms. He was sentenced to 25 years imprisonment on importation of the drug and 5 years imprisonment of possession of some other drug. The sentence, in fact, says sentences to run consecutively, but that must actually mean concurrently.
Well, it certainly can't mean consecutively in respect of 1 to 4.
Well, it can't. Or 1 to 4 plus 5. Oh. Well.
Again, my lords, we look at the fact that it's quite a substantial amount more than what the appellant is present before the court of bar.
Well, I understand that you're moving on from the point which I don't think we've fully resolved, which is the position that this appellant would be in
And I am aware of the issue having been raised, but there must, Mr. Clark, be any number of cases where non-Bermuda nationals, aliens, if you will, are serving their sentences in Bermuda. And I'm aware, in recesses of my mind, that each one of them took proceedings.
Yes, so that is Martin Cashman. And I was just looking to see whether those proceedings were appealed to this court. I found the Supreme Court judgment, but I don't know whether or not.
When was Cashman?
It's number 2009, number 362, and it was a judicial review.
I remember the case.
As do I, my lord. I was just trying to see if they appealed the decision by then Chief Justice, actually, I don't think he was chief, by then Justice K. Willie, as he then was that the judicial review was refused, but he did make comment at paragraph 46 that Mr. Johnson, for the applicant, has raised arguable questions as to whether or not the differential treatment afforded to foreign prisoners who cannot be released on parole to their home countries under Section 14A of the 1979 Act contravene the applicant's rights under Section 5 and/or Section 12 of the Constitution. So it's a substantive relief for any contravention of such rights is only potentially available by way of an application under Section 15 of the Constitution, not by way of a judicial distortion of the unambiguous provisions of Section 12, as read with Section 14A of the Prisons Act.
So Mr. Cashman did not, in practical terms, secure any reduction in sentence?
He did not. I know that Mr. Zagelis was in fact repatriated to Latvia, but I don't know whether or not once he arrived.
If he was repatriated, that must have been well before the end of his sentence.
Yes, but I don't know whether he was entitled to parole once he arrived in Latvia.
Well, there are obviously arrangements in relation to Zagelis, which would have led to Mr. Zagelis' repatriation to Latvia. So,
Yes, my lord, I know that there was an application made to His Excellency at the time, and I know that my learned friend and colleague, Ms. Shakira Del Francois, appeared on behalf of the Attorney General for that repatriation hearing.
So one can presume that that is a procedure which would similarly be open to Mr. Vlcek.
It is open to Mr. Vlcek and to every defendant who is an inmate to make.
But that still begs the question as to whether, if that is successful, he serves the remainder of his time in Poland or Latvia, or less than that.
And I'm afraid I can't assist the court. I can try to find out if there were agreements that were made, but I know that wasn't part of any legal issue.
That would depend on the regimen operative in, let's say, take Mr. Vlcek's case
Yes.
in Czechoslovakia.
That's correct. I do remember there were some issues with Mr. Zagelis' matter that Latvia took importation of drugs far more seriously, and I believe they still had death penalty provisions. So I know there were some discussions about how long he would have to stay incarcerated versus when he could be released. But I don't know if it was the same sort of 1/3, 2/3 that we have in our legislation.
I remember the case of, I can't get them, Adelaide.
Oh, yes, Remenito Adlawan, similar circumstances for him.
Sorry?
Similar circumstances for him. Mr. Adlawan was
And
Filipino.
he was complaining that
He did not want to be repatriated to the Philippines, yeah. Because of same situations. Duterte was
took a much
seeking
more
death.
serious view of, yes.
So,
Thank you. I hope that's helpful, Ms. Gaskin.
Yes, my lord, thank you. The appellant also, in the sentencing, is complaining that the sentencing judge did not take into account what is colloquially called as hard time, specifically the issue of
Not take into account what?
the issue of what is colloquially known as hard time, the circumstances of which he would be serving his sentence.
I
Specifically,
didn't get the word before time.
Hard.
hard time.
Hard time?
You would have a hard time in prison. That's what it means.
That his time in prison would be harder
Mhm.
due to the estrangement of Bermuda's culture, also the language barrier, and difficulties he would have adjusting to the prison community. Unless I can be of further assistance.
Well, is that you say that the starting point before the 50% uplift for importation of this amount of drugs is 12 to 15 years? I mean, are there any cases that show that?
Well, we had the recent case of Omar Davey, which
Yes.
was 12 to an up with the uplift 18 in respect of a significantly lesser amount. And I
Yes,
believe
my lord.
that's-
It is, but
And I believe he also had a large quantity of cash.
Who?
Mr. Davey, I believe there was a significant sum of cash that had been seized.
I don't think so.
Not,
I mean, there were two real issues in this Davey case. And then the appropriate sentence starts at paragraph 22.
Could I just intervene here to say that at page 141 of the record, the defence, I'm not clear what the defence submission was at trial. At line 20, the judge states the defence submits that it's not possible to argue that the starting point should fall below 18 years, or rather that the imprisonment should fall below 18 years. Well, which was it? Was it the starting point, or was it the total length of imprisonment?
yes, my lord, I see it at paragraph 26.
26?
Yes. More generally, Ms. Christopher criticized the judge for not having found a starting point. In fact, while the judge did say that he did not feel the Crown's suggested sentence of 18 to 21 years could be challenged, he said in terms that he would take a starting point as 12 years. With that, a 50% uplift would have been 18 years.
right. Well, anyway, you say it should be before the uplift, starting point of 12 to 15, with if you add the 50%, that gets you to 18 to 22 and a half. And you say that there should be a reduction because of the fact that he is Czechoslovakian, and on that account can't be on parole in Bermuda, and would have a hard time in prison. But what do you say we should do in order to take into account the fact that he's not entitled to parole in Bermuda?
My lord, that would be where I would be respectfully submitting that ought to be where a decrease to what would have been the standard sentence be given in his benefit. Considering that an ordinary citizen of Bermuda would only serve 1/3 before parole.
Well, 1/3 is the point at which application can be made for parole.
Right.
But as I understand it.
Or 2/3.
Sorry?
Or 2/3 release as well.
Yes. And it's open to him to make a representation through the governor's office for repatriation to Czechoslovakia.
Yes, my lord. And at this point, he has been at Her Majesty's pleasure since 2017.
Yes.
But I mean, taking that in the way that you suggest, that would appear to indicate that you should take, well, on the footing that the starting point is 12 to 15. No, on the footing that the starting point is 18 to 22 and a half. If it was 18, he would, if he got out for parole, serve only 6. So are you saying that the sentence should have been 6? And in order to account for the 50% increase, should it have been 4 plus 2?
No, not for the quantity of the drug.
Well, I'm afraid I'm a little lost as to how you say, because these things have to produce a figure.
Yes.
How you say we should take account of his difficult or his inability to obtain parole in actually reaching a figure.
And I would just make the point that Davy concerned the case of a Jamaican national, and so the position would be just the same as that of a Czech national.
So, my lord, it would be the appellant's position that the sentence ought to be reduced to what would have been 2/3, and the benefit of he would have received had he been local and able to receive parole. And the reality is that Jamaican national Mr. Davy did speak English.
Should be reduced to 2/3 or by 2/3?
Reduced to 2/3, my lord. Because had he been a local, he would have had the benefit of release at 2/3. You can apply at 1/3.
Right.
Standard expectation for release would be at 2/3.
Oh, I see.
But we can't find any other case where that has been done, can we?
No, my lord.
And there have been many persons such as Mr. Davy, whose appeal was dismissed relatively recently, where there was no reduction of the sort you described.
Yes, my lord. I believe his complaint was with regards to not entering an early guilty plea due to the conduct of counsel. That was his complaint.
Sorry, could you repeat?
I believe his complaint related to the conduct of his counsel and improper instruction. For Omar Davey?
Are you talking Davey?
Yes.
Oh, that was in respect of matters that affected the conviction.
Right.
So it had no relevance to the sentence.
Right. Well, thank you.
Thank you, my lord, my lady.
Ms. Clark.
Grateful, my lords. We did file the Omar Davey case as well as the case of Barry Rockman. I don't intend to go through them, but as my lords have pointed out, Mr. Davey had 18 years imprisonment after trial for a substantially smaller quantity of heroin. My lords, I would submit that the reason why Mr. Davey's parole consideration was not dealt with by this court is, in my humble submission, I believe we have to be careful walking down a line to sentence a foreign appellant different from a local. And I'm sure that there's authority on it, and I apologize for not being able to find it quickly while I was here.
I don't have any difficulty understanding.
I'm grateful, but I know that there is authority that says that no sentencing judge in first instance should be considering potential parole release dates when setting the appropriate sentence.
Yeah.
And so I would commend that same position to this court.
And in terms of de facto lower sentences for locals, that could be said quite easily to equate to discrimination against foreigners.
That's correct.
So if you want redress, you've got to apply under Section 15 in the Constitution.
That's correct, my lord.
Right. Yes.
That being said, my lords, I would submit that 30 years is neither harsh nor excessive on the facts of this case. This case was the largest importation of heroin to date. And at first instance,
I mean, frankly, I was surprised that this amount should have proved to have been great quantity, because it's not that large.
no, but it seems in our history, we spend more of our time on cocaine than we do on heroin. There aren't as many heroin cases
Yes.
as there are cocaine cases.
One might almost wonder whether the factor that one might take into account, bearing in mind different drugs, and we don't really have much experience of sentencing in relation to fentanyl, do we?
Only the one. There's only been one case for
Which is the
fentanyl.
Canadian woman.
Yes, whose name was.
I'll remember it when you remember it.
Because I was in that case too. Actually, I can be unfair. I can search my files.
Well, I only use that by way of.
Jacqueline
example.
Robinson.
Robinson. One might almost think it makes more sense to have regard to the value, street value or otherwise.
Well, one is required to do so.
The range went from what, 17 million to 48 million, depending how it was packaged.
Yes.
In other words, it was a huge importation, and one can understand why it attracted a heavy sentence. But
Well, what I will
The
say,
logic of saying, well, that was the biggest importation of cocaine, this is the biggest importation of heroin, heroin's worse, therefore it should be more than 25. I have a little difficulty with that.
so yes, my lord, I would argue, well, not argue, I would agree with my lord, but the history behind how that came to be is the common law previously found heroin to be more serious than crack cocaine,
Yes,
which was cocaine,
hydrochloride.
no, hydrochloride was the power, I can't remember now, but one of them was separated out from the other. And then crack cocaine was considered to be worse than regular cocaine, powder cocaine, if I can call it that, which of course was considered to be worse than cannabis. What happened was we had an amendment to the statute on around 2005, 2006, which brought into case classifications, which Bermuda had never had before. We only had our common law. And so then now we have a statute that says you have to treat cocaine, diamorphine, and methylene dioxymethamphetamine as more serious without differentiating
Between
the three. And that was Ms. Mulligan's point at first instance. But our case law still references diamorphine and now fentanyl being treated at a much higher level than any of the cocaine or MDMA offenses.
But the sentencing judge, Justice Graves, who
Yes.
we all know was very experienced in these matters.
And he in fact reflects it in his sentencing comment. He does indicate that notwithstanding the change in statute, history, and
He still wants to consider,
Yes.
and still does consider.
and so does consider that diamorphine is more serious.
Yes.
And I would say he is entitled to do so. And he makes his comments, my lord, at the record of appeal on page 146. 146, line 2. And at this point, he was speaking about the types of offenders who usually receive 30 years and higher are those convicted of gang offenses.
One 146 line.
2, at the end, it says it.
Yes.
It may be that a gangster may have caused the life of one person for which he is tried and might have affected by his actions the lives of several others. For example, those who feel the loss and the consequences of the loss. I think likewise are drug dealers, particularly those who deal in particularly hard drugs. Diamorphine is at the high level of addictive drugs, surpassed only by fentanyl. It is said that it is 50 times or thereabout more lethal and potent than cocaine. The history is clear, and well, I think it should be known, how it affects so many, sometimes resulting in the loss of life of many in many different ways. So he goes on to say, so yes, although the violence is not direct in these cases, it is still as cruel in many cases as it is in the direct violence and homicide cases. So my lord, I would indicate that the judge has not made any wrong consideration of law in this sentence. It is not out of line with the recent sentences for heroin offenses. And there's been no wrong approach to sentencing procedure. So if I might, my lords, just to go back to this morning, I would ask that this application be dismissed in respect of conviction as well as in respect of sentence.
Thank you.
I'm grateful.
To retire. To retire. Yeah. We'll retire for a moment, if we may.
The interpreter is speaking is Mr. Kualoda. Hello? Oh. Ne, nikdo tam není. Teď ne. Pauzu, jo?
Mr. President, you need to unmute.
Contractor?
My full screen.
Madam Interpreter? Could the prison authority confirm that they're still on the phone with the interpreter?
Directions are muted.
I apologize. I'm so sorry.
Okay.
I'm so sorry. Ms. Cassidy, is there anything you wanted to add after the Ms. Clark's submissions?
No, my lord, thank you.
Well, I'm sorry to have kept you waiting. We're most grateful for the submissions that we've received, and we're particularly grateful for the assistance of the interpreter, who's had a long day with a lot of complicated material to interpret. We shall reserve our decision, which we will endeavour to give as soon as possible. But for the moment, we shall simply retire, and the proceedings today are complete.